morning.
Good morning, everyone.
Good morning. Good morning. So it was a first for us. There, you can all see. You have a seat. No, nothing in Judy. No. Nothing in Judy.
We're just trying to be out of here as quick as possible.
We all have the same sentiment.
Well, okay, so my concern was yesterday with the protests. I thought we would have a lot of people. But I've been told by the officers that there were no arrests.
Okay.
So, yeah.
We're still waiting on a few felonies.
You're on card on the TV. Yeah, I have to give your priors.
Yeah.
Oh, yeah.
We're cheating. Let me get it.
Okay. Oh, there's. Yeah, just let me know the priors. Oh, beautiful. Beautiful. You're the best. You're the best.
Yes, ma'am.
Yeah, listen, yesterday we had an issue with the stay rate orders because the state was just putting the initials.
No, they just put the name.
That's what I had them to do that
Yeah.
yesterday. Yeah.
We have the names of this.
Okay, all right. Yeah, because,
What you want, Joanna?
Timothy with cream.
The identifier.
Two, three? How many cream?
Oh, yeah.
What's the name?
I might have a couple. Oh, which one? I might have a couple of those donut holes if you get a bunch.
Or the glazed ones?
Okay. Thank you. You're the best. Good morning. How are you? Pre-trial services.
How you doing, man?
Doing great.
So you caught the hang of it yet?
So, well, yeah, I was here yesterday, and about 1 million years ago, I was a criminal defense attorney. So I kind of spent my entire legal career in this building.
Oh, okay.
But I've been in civil for almost 20 years. So.
Oh, okay. They come back to you might do something in a while.
Yeah. So yesterday I had very few people that were eligible for pretrial.
Yes,
Do you have it in today?
yeah. They qualify no priors.
So, so they qualify.
Yeah. This here, because we are no plus, and because even though it's it's like a battery,
Okay.
so but
Does not qualify.
yeah, it does not qualify.
Okay. And then qualify.
Different qualifiers,
Right.
same thing.
No.
Yeah, no.
Okay.
I mean, you can order them in if you wish.
Okay.
And this one has a Eastwood St. Louis.
Okay.
These two qualify.
Fine. Right.
And the last one,
Also.
yeah, like a battery.
Okay.
Yeah, battery, there was no action. So the date, you go to date for that, the 2000 for battery, 2011, no cross. And last one, no action, 2000. To me, they qualify, but if you put them second to that,
Okay, but I can remember.
you go order them.
All right. Okay. Yeah, because unless there's no.
Yeah,
Requires any.
yeah, it's always the same thing.
Yeah.
You don't qualify. It just happened last year.
That was, which has Amazon.
Yeah.
Doesn't qualify.
You don't want that. Oh, I didn't have 45 one day, going to school, pick up.
Yeah.
There was something like that. I can see, like, very, I can see one this.
Yeah.
In the dark.
Yeah.
Look up.
It's funny because over the years, I have my dreams, and every so often, my dream, can I make a little bit bigger?
Yeah. Well, everybody got me reading the gift card and print it up. And I just missed it completely, so now they're highlighted.
Okay.
Yeah, the way they're right on it, so I just.
You want? I'm sorry. Yes, your line. Yes. How do you? Oh, you didn't have, okay, we need my file. Okay, yeah. Okay. Correction is actually advertising.
Okay.
Good morning, Your Honor. This is APD Sarafi for the record.
Yes, I will, video.
Okay. So, whose divisions are you guys in?
He's in Harrison, Nelson, I'm in Alvarez.
Oh, great, great. They're both very, very good judges, very dear friends.
Very good. Are you civil?
Civil. I'm in Coral Gables, but I was a criminal defense attorney, so I know Julie from back in the day because Julie was the state attorney, and Julie and I both have a little rivalry because she's a Wolverine and I'm a Buckeye. So you can tell her tomorrow that you spent a great weekend with just a wonderful Buckeye.
I'm gonna tell you one. I'm sure she'll remember it.
Oh, I know too well.
She loves it.
Oh, she sure does. Her only downfall in life.
If you see on the street, this open.
And the DV bonds have gone down. The last time the bond, it was 1,500 standard, now it's 1,000.
We're gonna take their, Giovanni one, that's gonna be the first one, out of turn, okay?
Owens?
Hold on. The only bread and go. Sometimes, okay. Like I do the virtual,
Yeah.
it's 3,000. Up to that. And they can have nothing, just nothing.
Easy.
Up to this. Yeah. I don't say nothing, but you know.
Yeah, I know.
I'm definitely missing DV.
I know, but personally. It's one slide over there.
Yeah.
And I have to go back to the.
It's gonna be a quick day. Not
Yeah.
fun.
Oh, yeah. I
He was here, he came, and I had to take the day off, I didn't want to.
Yeah.
That's cool. I mean,
But
you're like,
Give or take.
Yeah. Yeah. I mean, when I spent, like I sat in South Bay for 4 years
yeah,
and I had a domestic violence.
So it's gonna be. Oh, you're crazy about that.
So.
This correction.
no, you really think about it. When OJ committed that crime,
Right.
they started to spread. They started, she got in now.
Yeah.
Well, she had it out. It just made it harder for innocent. And then
Corrections, are we ready?
We can start.
Todos, por favor, pónganse de pie y levanten la mano derecha.
Push it, that mean it's muted. You let me know if it's muted. When I push it, the red light come on.
it should come on, just press it.
Can I have all the defendants please stand and raise their right hands?
Todos los acusados, pónganse de pie y levanten la mano derecha. I don't think they can hear us.
You can't hear us.
I can hear you all, but I don't think the defendants outside can. I'll go talk to corrections.
Who's speaking? Okay, all right.
They listening to a tape. Okay, they call a Quinn. Okay, no
Okay.
problem.
All right.
Thank you.
Okay.
Okay. Wave your hand when you're ready. Okay, there we go. Do you swear affirm once again today will be the truth, the whole truth, and nothing but the truth? Please say I do.
Juro, no afirman que el testimonio que van a dar es la verdad, toda la verdad y nada más que la verdad. Díganlo, juro.
All right, first case on calendar, State versus Giovanni Owens. Good morning, Mr. Owens. You're being charged with the count of battery. And state, let me know if there's priors.
No priors, Judge.
You asking for the standard bond, Your Honor.
That's review of the arrest form. The court does find probable cause. I'm being advised that he does qualify for pretrial services. So the court's going to order pretrial services, the alternate bond, standard 1,000. In addition, for your condition, I'm also ordering you not to engage in any criminal activity, not to use or possess any illegal drugs, to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition, and to have or prohibited from contact either directly or indirectly with the alleged victim, in this case, Daria Lawrence. Do you and Ms. Lawrence reside together?
Yes.
Okay. So on that basis, I'm going to allow you to return to your former home on one occasion, but you will have to go with the informed police officer to retrieve your personal items. You understand?
Yes.
All right. Good luck. Yeah, give me some- Okay, okay, thank you. All right, next case, Dianelli Siri Alonco. Yeah. Yeah. This is the new one.
And Judge, this is ASA Juan Sarceno for the state. She also does not have priors.
Ms. Alonco, you are being charged with one count of battery.
Yes, Your Honor. The public defender accepts appointment, enters a plea of not guilty, demands discovery, and asks set a date for trial. We would be asking for pretrial services as this is her first charge. And I would like to note that she was serving an injunction on the alleged victim at the time of arrest.
I do note that.
And Judge, the state would still ask the DV, the stay order, be read. It does reference an injunction, but we're not sure what type of injunction. I think the D1 must be put in place.
All right, what I'm gonna do is court judge is gonna find probable cause and order pretrial services with alternate run of 1,000. In addition to that, I am going to order conditions on the pretrial release. Namely, you're not to engage in criminal activity, you're not to use or possess any illegal drugs, you're not to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition, and you are to have no contact, either directly or indirectly, with the victim in this case, Don Allen. Do you and Mr. Allen reside together?
She informed me that he lives in her house. So I don't believe it would be a problem.
What? I'm sorry to hear the question.
Does he live with you?
He's not allowed to. The injunction. He was living in my apartment and he's not.
So you have possession, full possession of your home? Okay. Your turn. All right, but no contact with him. Okay, good luck, man.
Thank you.
You're getting released.
Okay, but I'm sorry. What was it that she was saying something else aside from the free trial? Was there
Alternate $1,000 bond. So if you get arrested, your bond's gonna be 1,000. If you get arrested again.
okay? Thank you.
So you should qualify in a stay away order.
Yeah.
And public defender, can you turn up your volume? We're having some difficulty.
Yeah. Is it the mic? Is this easier to hear? I'll just get closer to the mic.
All right, Linda Ortega Morales. Ma'am, you're being charged with one count of domestic battery.
And Judge, she also does not have any priors.
At this time, the public defender accepts appointment, enters plea of not guilty, demands discovery, and asks set a date for trial. We'll also be asking for pretrial services, given that she has no priors.
The court's going to go ahead and find probable cause, enroll her in pretrial services with alternate bond of 1,000. In addition, I am also going to order as conditions of her pretrial release that she is not to engage in criminal activity, not to use or possess any illegal drugs, to use, possess, or carry a firearm, gun, weapon, or ammunition. And she is to have no contact, in this case, for the alleged victim, Pedro Feliano.
You
Te dejo un regalo. ¿Lo viste? Jorge.
She speaks English.
Okay, do you understand?
Jorge. No lo escucho.
Do you understand?
Yeah, I understand.
Okay, all right, good luck to you.
pick it up.
Yeah. So,
Ada Victoria?
I'm sorry, did your honor say Zapata?
Yeah, Zarada Zapata Victoria.
English?
No.
Spanish?
Prefiero español. sí.
Okay, she speaks Spanish.
Your interpreter is connected, Your Honor. Good morning.
Okay. All right, Ms. Zapata Victoria is being charged with 1 count of battery.
Buenos días, señora Zapata. Usted se le imputa un cargo de agresión.
Ujú.
All right. Do you have anything to say?
Yes, your honor, we'd be asking for pretrial services. I don't see any priors on her record, an alternate bond of $500.
Your Honor, if we could just wait a minute, I see here that the defendant, at least in our last page, it says they weren't positively identified prior to the cutoff, so we're just running a pit umbrella real quick to make sure that there are in fact no priors. It'll take us less than 30 seconds.
Okay.
Un minuto, por favor, mientras que la fiscalía chequea sus antecedentes.
And yes, Judge, we couldn't find any priors in the system in our quick search.
All right. Based upon review of the A form, the court does find probable cause. I will enroll her in pretrial services with the alternate bond of $1,000. In addition, I am going to order her as a condition of a pretrial release, not engage in criminal activity, not use or possess any illegal drug, not to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. And most importantly, she is to have no contact either directly or indirectly with the alleged victim in this case, Jose Zapata. And I do believe that the couple does reside together, and I will allow her on one occasion to return to her former residence to obtain her personal belongings, but she needs to do that with a uniformed police officer.
Muy bien, usted no tiene antecedentes penales, así que su señoría encuentra causa probable para el delito que se le imputa y la va a liberar bajo la supervisión del programa Pretrial Services o de manera alternativa, usted puede pagar una fianza de $1,000. Además, su señoría va a establecer las condiciones para su liberación previas al juicio, que incluyen que usted no puede participar de ninguna actividad delictiva, usted no puede tener, usar o consumir sustancias ilícitas, usted no puede tener, portar o comprar armas de fuego o municiones. Además de eso, usted no puede tener contacto alguno con la supuesta víctima. El contacto no puede ser de manera directa o indirecta. No puede contactar al señor Zapata. Creo que la pareja todavía vive junta, así que yo le voy a permitir retornar a la vivienda una sola vez para que recoja sus artículos personales y tiene que asegurarse de ir acompañada con un agente uniformado.
Does she understand?
¿Me entendió?
You understand?
I don't have anywhere to go.
Your honor, we would just be asking if that your honor granted no harmful contact order instead of a stay order from her husband. She has nowhere else to go, nowhere else to live.
Judge, just
Señoría, le solicitamos por favor que usted modifique la orden de contacto porque ella no tiene a nadie y es el único lugar donde tiene para quedarse.
Yeah, based upon the arrest form, I'm not going to modify it, but she can always address the her judge in DV for the modification. I can't do it at this point.
Yo no voy a modificar la orden debido a las alegaciones que están incluidas en el atestado de arresto. Ella, si quiere, más adelante puede cambiar esto con el juez que se haga cargo del caso de violencia intrafamiliar.
Yes, Your Honor, and if I hadn't said before, the public defender accepts appointment, enters plea of not guilty, demands discovery, and asks set date for trial. Okay, you're getting released.
Carlos Cortez Anderson.
Good morning, Your Honor.
Good morning. Good morning. You're being charged with one count of domestic violence battery as well as one count of criminal mischief.
Judge, this is also a defendant with no priors. However, in this case, we would be asking for a standard bond. I see here that the date of incident is different than the date of arrest, which signals the state concern, which it may be that this person may have been avoiding law enforcement for some time. So if we could have just a standard bond on both counts.
Your Honor, the defense does not see anything that would indicate that he is avoiding law enforcement in the arrest form. We would be asking for pretrial services, given the fact that he has no priors.
But in the arrest form, the arrest is made just on June 14, 2025, yesterday. But this incident stems from November 16, 2024 date of incident.
All right, well, first I'm going to do is based upon review, court is going to find probable cause. I'm being advised that he doesn't qualify for pretrial services. So what I'm going to go ahead and do is set the standard bond, 1,000 on count 1 and 500 on count 2.
How much was the bond, Judge?
1,000 count 1, 500 count 2, 15.
And public defender accepts appointment, enters plea of not guilty, demands discovery, and asks for trial.
Derek Keith Rivers, Virginia.
And Judge, if they could be read the stay away order on this.
Oh, yeah, Mr. Cortez Anderson. Yeah, come back, Mr. Cortez Anderson. I'm sorry, in addition to the bond, I am going to enter a stay away order. You're not to engage in any criminal activity. You're not to use or possess any illegal drugs. You're not to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You're not to have any contact, either directly or indirectly, with the alleged victim in this case. And I do need the name in the stay away order. Do you understand this condition?
Yes, ma'am.
Good luck to you.
Thank you.
Good luck.
Thank you, ma'am.
Good morning.
Hey, how you doing?
Good, how are you?
Pretty good.
All right, I'm gonna,
Dave, I do have initiatives for this. In the stay away order. Yes, sir.
Judge, in this case, it would be a Marcy's Law victim.
Okay. I need the name.
Oh.
We were, yeah, we had this issue yesterday.
On Marcy's Law Judge, you need the names also? That's what he's saying.
It's a Marcy's Law victim, so they're protected from having their names in the public record. We can put it.
Stay away order. It's a stay away order.
So in how it works is, I think you tell them the name here, and then in the stay away order, you only show the initials. We can put just the initials on the first, and then fill out the other ones that are copies kept by the state with the name.
I don't understand that, but we're gonna move on. Derek Keith Rivers. Is that Mr. Rivers?
Yes, ma'am. How you doing?
I'm doing well, sir. You're being charged with one count of domestic violence.
don't say just speaking.
And Judge, this individual also has no priors.
We will be asking for pretrial services for Mr. Rivers.
Does he have priors?
No priors, Judge.
Does he have a local address?
No, Your Honor, he informed me that he is from St. Louis.
That's the information that we have.
And we'd be asked to set this on a homeless calendar. If Your Honor is inclined to give pretrial services.
Yeah, he doesn't qualify for free file.
And Judge, we asked that this be transferred to DV, not in homeless calendar. He has an address in St. Louis to make his appearance through Zoom.
Your Honor, we asked that he get a date certain. He can't get mail. He's in Miami. Can't get mail in St. Louis.
I mean, is St. Louis his permanent address or has he moved here?
His permanent address is in St. Louis.
And that's where he resides with the alleged victim.
Not with the alleged victim. He resides in St. Louis. He does not live with the alleged victim.
He does not live with the alleged victim.
No.
Yeah, I'm not going to put him on the homeless calendar. What I'll do, the course is going to go ahead and find probable cause, and I'll set the standard 1,500. I mean 1,000. And as a condition of his pretrial release, I'm going to order that he is not to engage in any criminal activity. He's not to use or possess any illegal drugs. He is not to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. He is to have no contact either directly or indirectly with the alleged victim, in this case, Kiona Rivers. Does he understand that?
Yes.
All right, good luck to you, sir.
Yes, ma'am. What was the bond amount, Judge?
1,000.
And the public defender stands on their pleadings for Mr. Rivers' case.
Christian Dominguez.
Are you Christian Dominguez? Okay, see. Mr. Dominguez speaks Spanish.
The interpreter.
Yes, Your Honor.
All right, Mr. Dominguez is being charged with 1 count of battery.
Muy bien, señor Domínguez, a usted se le imputa un cargo de agresión.
He has no priors, Judge.
Su señoría no tiene antecedentes.
We would ask for pretrial services, and in the alternate bond, the standard bond.
The court's going to go ahead and find probable cause. I'll release him to pretrial services with the alternate bond of 1,000. In addition, I'm going to issue a stay away order. He is not to engage in any criminal activity. He's not to use or possess any illegal drugs. He's not to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. He's to have no contact with the alleged victim in this case. Yeah.
Judge, so how I've seen other judges do it in county court, at least, that they just say the alleged victims with the initials and then the initials in such case, and ask the defendant whether he knows who that is. And then if
in this case is Blanca Velasquez. You and Ms. Velasquez reside together?
Muy bien, señor. Encuentro causa probable para el delito que se le imputa. Voy a liberarlo bajo la supervisión del programa Pretrial Services o de manera alternativa usted paga una fianza de $1,000. De manera adicional, voy a emitir una orden de alejamiento, lo cual quiere decir que usted no puede participar de ninguna actividad delictiva, usted no puede tener o consumir sustancias ilícitas, usted no puede usar, tener, comprar o portar armas, armas de fuego o munición y no puede tener contacto alguno con la supuesta víctima, Blanca Velázquez. ¿Usted vive con la señora Velázquez?
And Judge, we're in Christian Dominguez right now.
Do they reside together?
Señor, ¿ustedes viven juntos?
No.
No?
No.
Okay. All right, does he understand the concept?
Muy bien, ¿entendió todo lo que le dije?
Okay.
En el micrófono.
1 second, Judge. Was this a case of Christian Dominguez? This current case, the defendant is Christian Dominguez? Because the
Señor,
that I see here, the victim is Dimas. Well, then the victim with the initial DD, not Blanca.
That's what I just received from the state.
¿Es usted el señor Cristian Domínguez? Porque acá la supuesta víctima es de iniciales DD.
Dimas Domínguez.
Dimas Domínguez.
Sí.
Yes.
That's the one that we just addressed, Christian Dominguez. Can we see this stay away order? Please. This one go with the last case. This stay away order goes with this case right here. This is Jose Road, and this is the other one. Yeah. Oh. All right. All right, then with the alleged victim with the initials DD. All right, no contact.
Bueno, no puede tener contacto con esa persona.
All right, that's going to take us to Jose Romero.
No.
Hola. ¿Habla español o inglés? Okay.
Do you need the interpreter?
Yes.
All right, Mr. Romero Villafranca is being charged with one count of battery.
Muy bien, señor Romero, a usted se le imputa un cargo de agresión.
Judge, this defendant only has a diversion prior.
Señoría, este acusado tiene simplemente un antecedente del programa de desvío judicial.
We will be asking for pretrial services and a standard bond for the alternate bond.
Your batteries.
Judge, so those are no actions. Maybe perhaps on the battery, I do see that it's from 2004. However, this relationship seems to be from 4 years ago, so I see it as unlikely.
La defensa solicita que lo pongan bajo la supervisión del programa Pretrial Services o de manera alternativa pagar la fianza estándar. La fiscalía dice que puede ser porque sus antecedentes datan del 2004 por agresión.
Okay. Okay, what I'm gonna go ahead and do is find probable cause. But I will release him in pretrial services with the alternate bond of 1,000. In addition, there's gonna be a stay away order. He's to have, he's not to engage in any criminal activity. He's not to use or possess any illegal drugs. He's not to use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. He's to have no contact either directly or indirectly with the alleged victim, Blanca Velasquez.
No contact.
Lie together.
Muy bien, entonces encuentro causa probable para el delito que se le imputa. Voy a liberarlo bajo la supervisión del programa Pretrial Services o de lo contrario, paga una fianza de $1,000. Además de eso, se va a emitir una orden de alejamiento, lo cual quiere decir que usted no puede participar de ninguna actividad delictiva, usted no puede tener o consumir drogas, usted no puede tener, portar o comprar armas de fuego o munición, y usted no puede tener contacto alguno, ya sea de manera directa o indirecta, con la víctima en esta causa, Blanca Velázquez. Ustedes viven juntos.
Sí, yo fui el que llamé a la policía.
Yes, but I was the one who contacted the police.
Okay. My question is, did the two of you do reside together?
Vale, pero mi pregunta era si ustedes dos vivían juntos.
Sí, bien.
Yes, we do.
So I'm going to allow you to return on one occasion to retrieve your personal belongings, but you have to do that with a uniformed police officer, and that has to be done within 48 hours after your release. Do you understand?
Muy bien, entonces le voy a permitir retornar a la vivienda compartida una sola vez dentro del periodo de 48 horas a partir del momento de su liberación. Usted tiene que ir acompañado por un agente uniformado a recoger sus artículos personales. ¿Usted me ha entendido?
Sí.
Yes.
Okay, good luck to you.
Buena suerte.
1,000. All right, that's all I have for the retrieving.
Hi, Miss Beatrice.
Hey,
Good morning.
good morning.
Yes, ma'am. Oh, thank you. What's the home about? My daughter's called. Not yet.
Oh, not yet.
I'm gonna tell you. My birthday was last month. My daughter called me from California, complaining about her marriage. And my other daughter called me the same day. Give somebody else a birthday, so I hope you guys. I'm grateful of baskets, I know. I thought they care.
Wow. You were here for me.
Then I reset it. Right.
Alright, so probably, you know what I guess. Oh, alright, just, yeah, no,
Okay, so it's there, all right. I was just on fire. Okay.
Yes.
Yes, we did.
Good morning, Your Honor. This is Joanne Hennessy from the city of Miami Beach. I'm here for the jail arraignment calendar.
My ex-girlfriend was from Ohio.
And was she calm? She was nice.
She was very calm. I would say something upset her. I would definitely hear about it though. But normal demeanor.
I'm not shy.
Yeah, I was gonna say normal demeanor was super nice.
Absolutely. So why is she?
Always ready to speak for us.
Question, Your Honor.
This uncompatible.
How much time?
What did you do?
And I really don't think either of us did anything. It was just like uncompatibility. But I did like her a lot. It was not one that has like a bad image in my mind, I'd say.
Yeah.
No. So before I came to Miami, I went to Florida State for law school.
Okay.
I practiced in Jacksonville civil, like.
You're in flower?
What?
Flower? You're in flower.
I already know. I don't know. But that's where I practiced, and then I came back home back in 2024. But it was during my time there that I was with her. Not so easy to find Ohio people here in Miami. You made the right choice. She was from Dayton.
Okay.
Yeah, no,
Okay, I'll put that tonight. Did you do that?
I did this car accidents personally. No,
Okay.
I would have handled the
Like,
stuff.
100%.
The fence.
Yours.
What's going to say? Yeah, under in guilty state speed. Yeah, so I was in the trenches at CSK.
Yeah.
They're pretty good here in Miami too.
Oh, yeah, that's 90% of my docket.
Oh my god.
So I did.
Going extinct though, so well, it should be like another year, maybe more. Oh Lord. I was excited to do a personal injury. There was always a risk of going to the PIP division, and I'm like, no, I want the facts. I want the exciting facts. That's why I'm doing this now. Here in Miami?
Here in this building. Here in this building.
So we're in good hands too.
Yes.
All right, good morning. The next case on calendar is Beatrice Calo-Catant. Is that Miss Calo-Catant?
Yes, Your Honor. Can you see her? She's sitting down.
Yes, right there she's sitting. All right, Ms. Calo-Catant, you're being charged with 1 count of trespass after warning.
And Judge, for her, we would be asking for an elevated bond. She has an open trespass after warning case. She has, in fact, 2 open trespass after warning cases, so that gives the state
Looks like she's
concern
set
of
for
a
trial.
pattern.
Your Honor, the defense would be asking for a dollar bond or in the alternative, an ROR. Miss Beatrice is a 63-year-old woman. She is almost fully blind. She cannot afford to bond out at all. I've confirmed that she has a place to stay if she is released, but she cannot get mail there. So I would be asking for a date on homeless calendar if she is released. However, I would just like to point out that this is not a violent crime. I don't even believe that she would be able to see or really hear well who has trespassed her, just from my brief conversation with her. So we would be asking for an ROR or in the alternative, a $1 bond.
And Judge, all these concerns addressed by the defense can be addressed by placing a bond on this defendant. That way we can make sure that about this hearing date for this case, but also the state has that concern of repeated crimes of the same aspect.
Oh.
Statement that one.
Right. I mean, what I can do is, I found probable cause, but I will ROR her and put her on the homeless calendar. And the return date is 7/16 at 9 a.m. in courtroom 6-7. I put it on.
Yeah, I know.
And the public defender stands on their pleadings.
And
Yeah, I know. I just
Judge, there should be a stay away order from a
yes.
location.
In addition to that, she is to stay away from the location at 16890 Northwest 67th Avenue in Miami, Florida, where that's the gap.
Just the public appointed.
And her PD's appointment.
Appointment that you plead not guilty, demand discovery, and ask set a date for trial. Here is your court date. You're getting released today, okay?
Okay, thank you.
And this is where you go for your next court date, okay?
I go where?
To this location, okay? You give this to your friend.
Okay, when is her hearing? Okay, and Ms. Public Defender, please advise her that she does have a hearing on July 2nd. It's a trial posture for the trespass and resisting cases.
Yes, Your Honor. Is that also in homeless calendar? Does Your Honor know?
That I don't have.
Okay. I'll have her call the public defender's office.
Information for let's
Wait, Judge. A second.
because I want to make sure that she appears.
Yes, Your Honor. 1 second. They're talking about her court date. Yes, 1 moment.
The hearing's supposed to be on July 16th, 2025.
No, this is July 2nd.
Good morning.
I want to go to the hospital, please.
I,
Yeah, the hospital.
the return date on the new case, or the homeless calendar.
I don't see that as additional date on the case, Judge.
What's this set for?
It was a report on 7/16. That's the one that I see. I don't see one on July 2nd.
Oh, okay.
It says trial.
I have July 16th and courtroom 6/7 for the open case.
Okay, so both can,
Yeah.
okay.
Okay, well, apparently that's been transferred to homeless as well. That's fine. No. Ariana Montano? Is that Miss Montano?
Yes, Your Honor.
Okay. Montano, has been picked up on a bench warrant. For film.
I can help you with the mental health program.
No, but you asked the judge to send me to the mental health program.
Okay.
You asked the judge right now. I want to go to.
The original charge for the petty theft.
And Judge, on this case, we would be asking for an elevated bond. This is a defendant that has multiple priors, and priors including this same type of offense. Furthermore, they bench warranted it before, so I do not think it would be appropriate to have this individual in ROR or any other sort of release. I think the appropriate thing to do is to give them a bond to ensure that they appear at their next proceeding and that it's elevated.
And Your Honor, we would be asking for a standard bond in this case. Ms. Montano also would like me to ask the court to place her in a mental health program. She knows that there is one in the jail, but would prefer a mental health program outside.
Mercy Hospital.
But we'd be asking for the standard bond.
Okay. Yeah, but this, she's not on the homeless calendar. This is a different, this is Ariana Montana.
Okay, what do you want to do with their custody?
Well, I'm gonna go ahead and just set a $500 bond, but she wants to put in some mental health.
Well, in 2 days, she's gonna go before jail report. And then at that point, she can make the request if she doesn't bond out.
Okay, so I'm being advised that in 2 days, she's gonna go to the jail report calendar and she can ask for help at that point.
Yes, Your Honor.
But I will give a $500 bond.
Okay.
Right, but there is also a stay away order from location 3401 North Miami Avenue.
Gonna send me to the hospital.
So
Also going to be a condition of her bond. Ania Cooper?
I got 2 cases.
I'm sorry, Your Honor.
Ania Cooper? I'm calling it
It's a bond out, Judge.
bond out. Okay.
But how about for the other?
Yeah. Eileen Nordal Tidewood?
Bond out.
And Judge, this defendant has no priors.
Bond out.
Bond out also?
Yes.
Najia Hugh or Kayla Najia Hugh?
Bond out.
Renisha Levon Merchant.
Bond out.
That's gonna take us to Mike Neal. Mike Courtney.
Are you Mike Neal?
Yes, ma'am.
Okay.
Mr. Neal is charged with 1 count of petty theft.
It's
And
an added charge.
Judge, the state would be asking for an elevated bond of at least $2,000 for this defendant. We have multiple priors, including felonies.
Yeah, he's got open cases as well.
Yes, Your Honor, defense would just be asking for a standard bond in this case. Mr. Neal cannot afford an elevated bond. He is unemployed and homeless. If Your Honor would be inclined to grant pretrial services, we'd ask for data on homeless.
Judge, the state holds that an elevated bond is proper here. Even looking at the priors, I could even see that at one point they even had a warrant, a fugitive warrant for out of state. So this is a defendant of the state would be worried we cannot guarantee his appearance at a trial setting without an elevated bond.
Right. The court will go ahead and find probable cause and set the bond at 500.
The
500 condition, there's going to be a stay away order. He's to stay away from location of 19501 Northwest 27th Avenue, Miami Gardens.
And Your Honor, Mr. Neal would like me to correct that he does not have a fugitive warrant right now. And the public defender stands on our pleadings.
And that's fraudulent practice to say that.
Are there warrants, corrections?
Yes.
There's a fugitive
Go
warrant.
ahead.
Judge, I mentioned that had a fugitive warrant in the past from out of state, so that was the concern.
Okay, but it's not an active warrant?
I mean, who mentioned a warrant, Judge? The state.
That warrant was squashed. It's from his priors, but you could see it in the priors, and that was the concern.
Right, so there is no current active warrant for the record.
Not that we can tell. Again, I had argued that in the past.
Okay, all right. Right.
Is the bond 500, Judge?
Fernando Bisono.
Judge, was the bond 500 for Mr. Neal?
Yes, ma'am. 500. Fernando Bisono.
Refuse court.
Morning. Oh, what's your name?
May I approach you? My name is Roy Ford. May I speak to you before we go?
Is that Mr. Bisono? No.
No, Your Honor, one moment.
Mr. Sono refused, is what I heard, Judge.
Yeah, he refused yesterday, but then somebody showed up. Okay. Defendant refused. Reset. Refused yesterday. Okay. Lázaro Gonzalez.
Refuse court. Reset for tomorrow.
Yesterday. Harvey Moises.
Reset for tomorrow. Refuse court.
Roy Angelo Forty Vega.
He's present, Your Honor.
Okay,
Good morning, Your Honor.
sir.
Good morning, State.
Forty Vega is charged with disorderly conduct as well as 1 count of criminal mischief.
And Judge, the state would be arguing for an elevated bond on this case. This defendant has at least at least 6 other priors. And for that reason, we believe that it would be appropriate to do an elevated bond as to both counts.
We would be asking for an ROR in this case, or a $1 bond. Mr. Forty Vega cannot afford a bond, and he currently,
I don't have any other.
one second, Mr. Forty Vega. We'd just be asking for an ROR or a $1 bond in the alternative standard bond.
And Judge, not being able to afford a bond is not a factor. At the end of the day, what the state needs to make sure is that they do appear, and in other occasions that there's community control in place.
Okay, well, the court's gonna find probable cause as to both, and I'll set the standard, count 1, 150, count 2, 150. So a total of 300. In addition, there's gonna be a stay away order. He is to stay away from location at 2000 Collins Avenue on Miami Beach.
Thank you, Your Honor.
Welcome, sir. Good luck to you. Cedric Phillips.
Refuse court, reset for tomorrow.
Also, Mr. Forty Vega, the public defender stands on their pleadings. I apologize, Your Honor. Got it. Hola.
That's gonna take us to Gaspar Mendoza. Is that Mr. Mendoza?
Yes, Your Honor. He needs the Spanish interpreter.
Judge, he has a hold for immigration.
Su señoría, el señor Mendoza tiene una retención migratoria.
Okay, and I've been advised by the state there is also an immigration hold.
Okay. Yes, for you, okay?
So Mr. Mendoza, he's being held on 2 bench warrants.
It's okay, it's okay.
And a new charge,
False name.
there was one count of giving a false name after arrest, one count of resisting officer without violence, and one count of consuming alcoholic beverage within 100 feet of the store.
And Judge, given that he got picked up on a bench warrant, we'd just be asking for the standard bond and then for that ICE hold to be placed.
Defense would be asking for a standard bond.
All right, so let's go ahead all right. Go ahead and announce cases on B200178822. There will be bond in the amount of 1,000.
Count 1, 2.
No, that was just the bench warrant amount.
That case has 2 counts, Judge.
After arrest.
Okay, but that was the same thing.
One is
He was
split.
charged. Yeah, let's do 500, 500.
I'm sorry, on the false name, Your Honor?
Yeah, false,
Okay.
500, 500.
I thought he was on case ending in 2-2, Judge.
17822.
Right, that case has 2 counts, 500, 500? Yeah, 500.
Okay, and then the B1902078 case. There was also
782, you mean?
the third counts.
No, but that only has 1 count, 782, disorderly,
Why do I
1,000.
have it? Oh, everything was, okay, I'm sorry. All right, the new forms.
Yeah, that's the warrant one, the other one.
Yeah, okay. All right, so there was one count.
Yes.
All right, 500. In that case. All right, and then the new case.
I'll let tu abogado on teléfono, okay? On the job, okay? Un teléfono por tu abogado en la jail, okay?
Mostly it's 500, assistant 500.
Excuse me, Your Honor, this is your interpreter. I do apologize, but will you be able to give me a sum up of what happened here? I'm kind of lost.
Okay, he had 2 other open cases in which he bench warranted on, and I just set the bond in those cases. I'm now addressing the current case.
Thank you, ma'am.
In which he's being charged with giving a false name after an arrest, resisting an officer without violence, and consuming alcohol within 100 feet of the store.
Muy bien, usted tenía 2 causas pendientes y su señoría ya se hizo cargo de estas, estableciendo una fianza para las órdenes de captura que usted tenía en su contra, ¿verdad? Ahora, con respecto al caso que se le imputa ahora, que es dar un nombre falso luego del arresto, poner resistencia al arresto sin violencia, beber alcohol a menos de 500 pies de distancia de un lugar donde se vende alcohol, su señoría ahora va a establecer fianza.
All right. So count 1, and the court will find probable cause. Count 1 will be 500 standard. Count 2 will be 500 standard, and count 3, 250.
Su señoría encuentra causa probable para los delitos que se le imputan y establece la fianza para el cargo 1 es $500, fianza estándar, cargo número 2, $500, fianza estándar y el cargo número 3, $250.
And there's also a stay away order from 280 Northeast 8th Street in Homestead.
Así como también una orden de alejamiento. Usted no puede acercarse al lugar ubicado en el 280 noreste y la 8 calle en Homestead.
And Madam Interpreter, he does need to be advised that there's immigration hold on him.
Y le informamos que hay una orden de retención migratoria en su contra.
Okay, thank you.
Tavares or Bailey.
No, Bailey. Come on, Bailey.
Good morning.
Mr. Bailey is being charged with 1, 2, 3, 4 counts of battery.
Judge, we would be asking for an elevated bond as to all counts. I'm looking here at the felony priors. We have aggravated battery on a pregnant woman where he took an adjudication, robbery strong arm where he took an adjudication. And if I look even later there, I see another battery conviction. Thus, you can see that he has a history of violent priors. So I think an elevated bond would be appropriate as to each count.
Defense would just be asking for a standard bond on all of these.
Okay, and say what are you requesting as far as elevation of the bond?
Judge, if the standard bond is $1,000, we're asking for a $2,000 bond in each.
Your Honor, if there's 4 charges, we just ask that each be the standard bond. This is already going to be a lot financially.
Which is going to find probable cause as to each count. You said the standard was 1,000.
So what?
Based on the fact there's 4 counts, I'm just going to do standard on each. 1,000 count 1, 1,000 count 2, thousand
Judge,
count
if we could
three,
get elevated at least on
and
one.
1,000 each. In addition to that,
That's 4,000 I got a bond up.
1,000, in addition, there's going to be a stay away order. And there are multiple stay away orders, multiple, I guess, victims. He's to stay away from Janaea Bailey,
But the victim is from out of town.
Devaris Bailey. He's stay away from Tamika Hester. And Javaria Kelly.
Don't contact them for now, okay? The public defender stands on their pleadings. Enter plea of not guilty, demand discovery, and ask set a date for trial.
Blake Howell.
Good morning, Your Honor.
Morning, sir.
Mr.
With one count of trespass after warning.
Judge, this defendant does have felony priors, as well as another open case in felonies. So we would be asking for a felony hold.
Okay, what is the, do we have the felony case number?
Yes, we do. The felony case number is F250-10326. And then the standard bond on the trespass.
Right, so there will be a hold on F250-10326.
Just call your attorney after this and get them.
Probable cause.
We would be asking for the standard bonds.
Standard 500.
And we enter a plea of not guilty, demand discovery, and ask set a date for trial.
Oh, in addition, there is a stay away order from 740 Ocean Drive in Miami.
Yeah, the bond is a hold.
Oh,
But you,
Eric,
my bond?
500.
Huh?
500.
Oh, so I could pay it. Okay, that's all.
or Sarah Pinales.
He has an immigration hold.
Morning. ¿Habla inglés o español? Okay. Mr. Carpunales needs a Spanish interpreter.
Mr. Carpinales is charged with one count of battery. We need the interpreter.
Yes, Your Honor. Señora, usted se le imputa un cargo de agresión.
And he does have an immigration hold.
Y además tiene una retención migratoria.
Yes, Judge. He doesn't have any prior, so we're just asking for the standard bond in addition to the hold.
Su señoría, él no tiene antecedentes y la fiscalía solicita fianza estándar.
We would be asking for the standard bond and enter plea of not guilty, demand discovery, and ask set a date for trial.
To find probable cause and issue 1,000 standard.
Su señoría encuentra causa probable para el delito que se le imputa y establece la fianza estándar de $1,000.
And I need a name. Yeah.
Judge, at this time, we don't have a first and last name for the victim.
Well, I have a last name.
All we have is the last name for the victim. Apologies. I think we need both for the stay away order. Yeah.
Yeah, I have no full name, so.
We'll make a note so that whoever does the arraignment can go ahead and.
All right, so there's no stay away order. There's just the,
Is this for Mr. Carl Guinales?
yes,
Okay.
just the bond and the ice hold.
Morning.
Oscar Gonzalez Noda? Is that Mr. Gonzalez Noda?
Yes, Your Honor.
We need the interpreter?
Do you speak English or Spanish?
English.
English, no, Your Honor.
Okay. All right, and Mr. Gonzalez Noda is the one count of trespass after warning. And he's homeless.
And Judge, the state would be asking to keep this defendant on bond. I see multiple priors, including felony priors. And I think the best way to make sure that he appears at the next hearing would be to have him in custody.
Okay, Your Honor, we'd be asking for an ROR in this case.
Please, I haven't done anything wrong.
Or in the alternative, a standard bond. That's what the defense would be asking for.
Please.
Court will go ahead and find probable cause. Standard bond, 500.
Judge, in
Okay,
addition,
and then also, I'm going to issue a stay away order. He's to stay away from the Miami International Airport.
and Judge, that stay away order should be limited in scope as if he does have to
Unless
travel.
he has a valid ticket.
Thank you.
Okay.
So they're not gonna let me out of jail?
All right, good luck.
Good morning.
Tony Montez DeFell.
Good morning, Your Honor. This is Joanne Hennessy for the City of Miami Beach. I'm here for the B25-8838 charge. And also there's a misdemeanor charge on the other one, but that's the state's case at this time.
You have this.
See if you can see it.
All right, so there's a bench warrant in B25008838 case. And that
Your
was-
Honor, in that case, we'd ask that the warrant be converted to a bond.
And Your Honor, we would be asking for a standard bond or a lower bond in this case. None of these charges are violent crimes. Mr. DeFell is a 20-year-old. He cannot afford any elevated bond in addition to all of these bonds added up. We would just be asking for a standard bond.
For the warrant, Your Honor, that is the standard bond, 150.
Yeah, the warrant is for 150. I'm addressing the case, the B258838 case.
Just to note that Mr. DeFell is an out-of-state address, so we're not sure, other than this case, if there's any priors.
Okay, so in that case, I'm going to issue the bench warrant amount, which was 150. And then we'll address the 2025-64070 case in which he's charged with one count of possession of cannabis, one count of smoking marijuana in public.
Sorry, defense would be asking for an ROR in this case.
Okay, who wants to be, I'm sorry, is this your case? Or is this the state's case?
It's the state's case, Your Honor.
Judge, I'm looking into the possession case right now to see if I can make an announcement on it. If you give me 1 second. So, Judge, as to the state's case on case number B250-12615, possession of cannabis, the state announces a no pros for discretion. That would leave the other city case open on that case, but I can go ahead and sign off on the state's case.
Okay, so count one.
Thank you, Your Honor. And in that case, we would ask for the standard bond for the smoking in public.
Okay, so count one will be a null pros. And count two, I'll find probable cause and issue 150 standard bond.
Public defender enters his plea of not guilty, demands discovery, and asks to date for trial.
So you make an announcement for count one?
I already announced it.
Yeah, he made the announcement of a null pros. John Lockley.
Yes.
Okay, Mr. Lockley is being charged with one count of giving a false name after arrest, as well as one count of possession of drug paraphernalia with the intent to use. And there was a bench warrant in the amount of $3,000 in case B25003-298.
Judge, and at this point, we would ask for an elevated bond. As you see here, there's a defendant that has failed to appear for this case before, and I think that's the best way to ensure that he appears at the trial proceedings. He also has a history of priors, including felonies, robberies, which include strong arm robbery, possession of controlled substances. Similar in this case, we have possession of drug paraphernalia with intent to use. We also have burglaries. He just has an extensive history of priors, including a similar one as to in this case to give a false name after an arrest where he was convicted.
Defense would be asking for a standard bond in this case. In addition, the bench warrant of $3,000, Mr. Lockley did inform me he took a plea on this and he just could not make it to the courthouse to take his fingerprints. So if your honor would consider a lower bond than $3,000.
Judge, nonetheless, he was picked up by the police. It's not like he got the bench warrant and then decided to call chambers and get that removed, right?
All right, I'll leave the benchmark amount and it'll be 1,500 and 1,500.
There's this,
Count one, count two.
no, there's no count two for the benchmark. It's just one count.
Well, what do I have? I have the same thing.
Which case are you addressing right now?
One.
The new A form has false name and drug.
Oh, he just was sure, but I saw the A form had two. All right. For the B25329A case, I'm gonna leave the warrant amount 3,000. This is the new arrest, and on the new arrest, I'll find probable cause. And I'll do 750 and 750.
Yeah, a little bit. The public defender enters plea of not guilty, demands discovery, and asks set a date for trial.
Juan Diego Rojas.
Good morning.
So Mr. Rojas has a bench warrant in case number B2324519.
And Judge would be arguing for the standard bond for this defendant, but we did want to make him an offer to close out the trespass to withhold and the criminal mischief case to an adjudication.
Is that something that you want to do?
Who is it?
I'm sorry, it was a withhold on the trespass and an adjudication on the criminal mischief?
Correct. And that's just an offer for the bond hearing and will expire after the bond hearing.
Is that on the new charges or?
It's on the new charges. We want the bench warrant to remain in place for the other case.
I have
You only have one charge.
one charge. I have indecent exposure.
Oh, sorry, Judge, my notes here were very confused. So we were asking for an elevated bond on the indecent exposure while giving him the opportunity to close out the both cases to withhold and an adjudication.
So there's no offer on the indecent exposure, but there's offers on the other two?
Correct.
All right, let's go ahead and. So he's being offered a plea on the B23 case, the
Correct.
24519.
The one that he was picked up on a bench warrant on.
Defense would just be asking for a standard bond.
As to all?
Yes, Your Honor, as to all. He has absolutely no priors.
And Judge, we would be asking for a rated bond as
On
to
indecent exposure?
as to the indecent exposure. Again, he was picked up on a bench warrant, and the older cases are from 2023. So that is a very long time that this defendant avoided justice for.
What's the standard on these?
Battery is.
The first misdemeanor and 10,000.
Yeah, and batteries in the north. But you can set it. False names, so 500. Only, sorry,
Okay. All right, so let me go ahead and find probable cause in the new case of the indecent exposure. Let's set a bond at 1,000. And then I'll leave the warrant amounts on the B23 case, which is 1,500 count one, I guess, and 25 count two.
Okay, so
2,500, 25.
No, the bond on that case, it was 1,500 on count one, and then they did a $25 bond for count two. But on the new case, it's 1,000.
and the public defender enters plea of not guilty, demands discovery and asks set a date for trial.
Okay, stay away order. He's to stay away from 417 Santander Avenue in Coral Gables. Malik J. Mason. Is that Mr. Mason?
Yes, Your Honor.
Okay, Mr. Mason is being charged with 1 count of petty theft and 1 count of trespass after warning. Okay.
Your Honor, there's no probable cause on this arrest warrant. They reference other police case numbers in this arrest warrant, but there is nobody on this arrest warrant that stated that they saw Mr. Mason take anything from a store. Or that he was trespassed.
Judge, the arrest form says that he had already been trespassed from that property before, and then we have an admission from the defendant stating that he did take the items from the store, indicating that he had been in the store.
I'm sorry, I misread that. We asked for the standard bond.
I do think that we have more than enough probable cause for the trespass and the petty theft. And although this A form might be a little broad, I think what the officer was trying to do was charge that prior petty theft and the trespass when he admitted to taking the items from the store. The state can go ahead and be more detailed in its information.
Just gonna go ahead and find probable cause. I'll issue the standard bond, count 1, 150, count 2, 500.
I can't pay.
Stay away from location at 14126 Northwest 27. No, for what?
No, you have a bond. 150. Call a bondsman. Get your attorney.
We will make an offer to the defendant to close out the cases for an adjudication if he wants to take it.
I'm sorry, an adjudication on what?
An adjudication as to both counts if he wants to take it.
One moment, Your Honor.
At the bond for the state road.
Mr. Mason advised me that he would like to take the state's offer right now of an adjudication on the petty theft and adjudication on the trespass.
I need to go home today. Fuck that. You give me out. Sorry. I'll take it. I just gotta stay away from that stove. Don't ever go back.
Right.
I got a job. I just started.
Court costs as to both counts.
Okay. What are the court costs as to count one?
Marcus will know.
It would be 358, Judge, 1 year to pay. And count 2 would be an SES.
Okay. All right. Sir, the state is offering adjudications as to both counts. On the first, it'd be adjudication court costs in the amount of $358 with 1 year to pay.
Yes, ma'am.
Would be adjudication, suspend entry of sentence. Sir, is this the plea you'd like to accept?
Yes, I need to get home today, ma'am. Yes, I will accept it.
Okay. Did you hear the rights waiver video that was played at the beginning of the sentence or session?
The rights waiver?
The rights waiver video?
They never showed me no.
I can briefly go over the right.
Okay, sir, by accepting his plea, you are giving up certain rights, and that's the right to go to trial, the right to have your attorney represent you. If you have immigration issues, plea might interfere with your immigration.
No, I do not have no immigration. I'm a U.S. citizen now.
Okay. All right. Do you understand you're giving up your right to go to trial and have your lawyer represent you?
Okay.
All right. All right.
Oh.
That, sir, I'll adjudicate you on count 1, impose court costs in the amount of $358. Adjudicate you on count 2, and I will suspend entry of sentence.
I'm going home.
Either today or early tomorrow. Okay.
I'll take that. Take that.
Yes.
So I don't got no next court date, no nothing.
Nope.
So I'll be going
Close
today
out.
or
You got
tomorrow.
2 guilty pleas. Yep.
All right, thank you.
All right, good luck to you. Gerald Page.
Refuse court. We said tomorrow.
Roberto Miranda.
Yes, Your Honor. Mr. Miranda needs a Spanish interpreter.
Miranda is charged with 1 count of disorderly intox and 1 count of resisting an officer without violence.
And Judge, in this case, the state would be asking for an elevated bond. This is a defendant that has previously been arrested for disorderly and taking a withhold on it, and also for resisting with violence, for which he also took a withhold. He also has other felony priors, such as a bat Leo. So we'd be asking for the standard bond.
Defense would be asking for the standard bond.
We would also be willing to offer this defendant an adjudication in court cost to close out this. So it'd be on each count.
Do you have any? Your Honor, if the Spanish interpreter could convey the adjudication court cost, I don't speak Spanish, just so he knows what it is.
Sorry, Your Honor. Is the charge is resistant without violence? Is that correct? I apologize for that.
Okay, it was a disorderly intox and resisting an officer without violence. That's correct.
Muy bien, señora. A usted se le imputa los siguientes cargos. Es embriaguez pública y poner resistencia al arresto sin violencia.
Two PNF, do you want, what do you want to take the offer?
¿Quiere la oferta o no?
Offer is
Declararse culpable. Culpable. Declararse culpable. Este
Is
cargo.
he,
and it would be the same education on one, court costs and SES on the other.
Correct.
Same amount, 358.
At this moment, yes, Judge. We wait for other, if there's an application sent in, it will be reduced to this.
Okay.
Mr. Miranda would like to accept the state's offer of adjudication court costs.
Ms. Miranda, did you watch the rights waiver video at the beginning of the court session?
Señor Miranda, ¿usted vio el video de renuncia de derechos justo antes de que comenzara la audiencia?
Sí.
Yes.
Okay. Did you understand those rights?
¿Usted entendió esos derechos?
Sí.
Yes.
Okay. Do you understand that you are giving up your right to go to trial and to have an attorney represent you at the trial?
¿Usted entiende que renuncia a su derecho de llevar su caso a juicio y de ser representado por un abogado en dicho juicio?
Sí.
Yes.
Do you also understand that by accepting this plea, you could have immigration consequences if you are not a U.S. citizen? Do you understand that?
¿Usted entiende que al aceptar este acuerdo declaratorio, este puede traer consecuencias de inmigración que incluyen la deportación si es que usted no fuese ciudadano de este país? ¿Lo entiende?
Sí.
Yes.
Okay. And knowing all of that, you'd still like to accept the plea of adjudication on the disorderly intox as well adjudication on the resisting an officer without violence.
Entonces, usted desea aceptar el fallo condenatorio en su contra por el cargo de embriaguez pública y otro fallo condenatorio en su contra por poner resistencia al arresto sin violencia, ¿correcto?
Sí.
Yes.
Okay, I'll adjudicate the defendant on count 1, impose the mandatory court costs, and as to count 2, I'll adjudicate him in SES.
Muy bien, entonces en el cargo 1 le impongo el fallo condenatorio y el pago de las costas judiciales y en el cargo número 2 también le adjudico el fallo condenatorio.
Okay.
Good luck, sir.
Buena suerte, señor.
You're good to go. You'll be.
Okay, Juan Carlos Montoya. Okay, Mr. Montoya was picked up on a bench warrant for failing to appear in court on June 5th. to answer to, I guess it was one count of petty theft.
That's correct. ASA Hunter Wiles, speaking for the record. State's gonna ask for elevated bond in this case. He has multiple priors of this exact charge. Or of some more charges.
There's a $500 bench warrant. I'll go ahead and impose a $500.
At this time, the public defender enters a plea of not guilty, demand discovery, and ask set a date for trial.
PC was found, Your Honor.
That was the case. Just took a plea.
Oh.
This is the guy that took the plea.
No. This way.
In Your Honor.
Oh,
Was probable cause found?
okay. And then Mr. Montoya, there's also a stay away order. You have to stay away from 3200 Northwest 79th Street in Miami, Florida, as a condition of your release. This is Miranda.
Wait, Your Honor.
Yes, sir.
I just want to make sure probable cause was found.
Yeah, probable cause was found. Rome, right?
He's present.
Okay.
You're wrong, McCray.
For the one count of battery.
State's gonna ask for elevated bond. He has a violent criminal conviction for robbery. We're gonna ask for elevated bond amount of $1,500.
What's a robbery cases?
I mean, these are very remote.
No, I don't have any priors of robbery. None of that.
Right, I see priors from 87, 85. The most recent was a petty theft in 2018.
We would be asking for a standard bond in this case.
Standard bond.
Yeah, this.
Yeah, so don't say anything, but the court's gonna go ahead and find probable cause. Issue a standard bond of 1,000. In addition, I'm going to issue a stay away order. He's to stay away from the alleged victim in this case, Roberts. No problem.
Okay, what?
Public defender enters a plea of not guilty, demand discovery, and ask set a date for trial.
Thank you, so noted. All right, William Gresham.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Good morning again.
Good morning. Your Honor, this is a warrant. I would just ask that the warrant amount be converted to the bond. And just to note, Mr. Gresham has multiple drinking in public convictions this year, as well as within the last 12 months.
Is that Mr. Gresham?
Yes, Your Honor.
Yeah, Mr. Gresham failed to appear in court. There was a bench warrant that was issued. He's been drinking in public. Homeless calendar.
Yes, Your Honor.
I'm sorry, I missed what.
Sorry, go ahead.
All right, who wants to talk?
We would be asking for an ROR in this case at a date certain on homeless calendar. Mr. Gresham advised me he was in the hospital at the time that this court date occurred.
I tried to call.
And did not willfully fail to appear.
All right. What I'm gonna do is, I am gonna ROR him. I'm gonna put him back on the homeless calendar. His return date, and Madam Public Defender, if you can also give him this information, is going to be
Yes, Your Honor.
7/16 at 9 a.m. Courtroom 6-7. All right, this is gonna be his last chance. He cannot miss that court date.
Yes, Your Honor.
Thank you, Your Honor.
Go to court and he needs to stop drinking.
You are right. You remember that date?
Max Angerville. Angerville is charged with an count of petty theft and count of resisting an officer without violence.
State's gonna ask for an elevated bond. At this, he has multiple priors of the same theft as well. We're gonna ask for a $500 bond on the petty theft and keep the $500 bond on the resisting.
We will be asking for the standard bond in this case.
Oh, has a conviction of resisting without violence as well, quite recently. So we're gonna once again ask for the elevated bond.
Pack of Hyman.
Your elbow doing okay?
What I'm gonna do is support with them and find probable cause. I'm gonna go ahead and issue the standard bond. Count 1, 150, and count 2, 500.
The defender accept enters plea of not guilty to demand discovery and ask set a date for trial.
There's also going to be a stay away order. He's to stay away at the location 2000 Collins Avenue in Miami Beach. John Hood.
How you doing, Your Honor?
Good morning. John Hood, Mr. Hood failed to appear in court.
State's gonna ask for elevated bond. He has he has an open felony, and that appear had a bench warrant issued.
Defense would be asking for a standard bond.
Yeah, we're gonna ask for a felony hold on the open felony.
Yeah, corrections, there's a open felony.
He'll be on a bond hearing calendar next, Judge, for that, to address that felony case.
New bill.
Oh, so he's gonna be on my felony calendar. Okay, so there's, bond hasn't been set yet, so.
Okay.
Like,
on this, and he's homeless?
It seems so. His permanent address is a highway.
yes, Your Honor.
No, I'm not homeless, but I got somewhere to stay, but I don't know how much time I gotta do for that. The max. How many years?
What was this charge?
This was petty theft.
Oh, this was a petty theft 1 count?
Yes.
I'll go ahead and set the bond at 150.
Yes, Your Honor.
Yeah, see you back. later this morning. And then there's also stay away. He's to stay away from 900 South Miami Avenue in Miami.
Enter plea of not guilty, demand discovery, and ask set a date for trial.
James Shadden. Is Mr. Shadden present?
I believe corrections is going to get him. Okay. Hey, Mr. Shadden? Yes, good morning.
Okay. Mr. Shadden, you're being charged with 1 count of trespass after warning.
Yes.
For elevated bond, he has another open trespass at this point. And so because of his likelihood citizen, we would like, or yeah, because it's open count, we would like to ask for an elevated bond.
And the defense would be moving to ROR, Mr. Shadden. There's no probable cause in this arrest form. There's no authority. There's no authority on the arrest form that gives the police officer the authority to trespass him from Jackson Memorial Hospital.
It seems he was found harassing patients and asking for money. And that, it's aggressive panhandling. So therefore, that's probable cause for him to kind of trespass him. So at least give it.
Advised by the officer.
Excuse me.
Be arrested.
And Your Honor, he is not charged with panhandling. He's charged with trespass, which under the statute, the officers have to be given authority to trespass someone either by a valid trespass sign or by someone from Jackson Memorial Hospital giving them the authority to do so. There's none in this arrest form.
And he's humble.
Yeah, the officer has a legal duty when he sees aggressive panhandling to at least try to intervene and be able to tell that person to get off of hospital property.
What I'm going to do is I am going to ROR him and I'm going to place him on the homeless calendar.
Are you finding PC here?
I'm going to find PC and ROR him. Place him on the homeless calendar. His return date is 7/16 at 9 a.m. in courtroom 6-7.
It was an RR, Judge?
Probable cause was found, Your Honor.
Probable cause was found. I'm ROing him and I'm putting him in the homeless calendar.
Okay, so this let me rewrite this. 7/16/25 is your next court date. You're going to be released today, but you have to show up to this court date, okay? Here's the address and the courtroom, okay? You understand?
Not really, but.
I'm going to issue a stay away order.
Okay.
Needs to stay away from 1611 Northwest 12th Avenue.
They're releasing you from jail.
Okay.
Okay.
Miguel D'Antonio Bartolome.
Yes, Your Honor. And he would like the Spanish interpreter.
Madam Interpreter. Let him know he's being charged with 1 count of petty theft.
Señora, usted se le imputa un cargo de hurto de menor cuantía.
State's gonna ask for standard bond.
La fiscalía pide fianza estándar.
Yeah, I don't see any, it seems the defendant does not have any priors at this time.
Is he eligible for pretrial services?
And you can order them in. Or write it up.
We would be asking for pretrial services.
La defensa solicita pretrial services.
Yeah, I'm gonna find probable cause for pretrial services with alternate bond of 150.
Encuentro causa probable para el delito que se le imputa, lo voy a liberar bajo la supervisión del programa Pretrial Services o de lo contrario paga una fianza de $150.
In addition, I'm gonna order a stay away from the location at 249 Northwest 6th Street, Miami, Florida.
Y además de eso voy a emitir una orden de alejamiento. Usted no puede ir al lugar, que es el 204 del Northwest y la 6 calle en Miami, Florida.
Tengo un trespassing de ahí.
You're gonna get released, huh? Mhm. Good morning. Yes, Your Honor.
State's gonna ask for, elevated bond. It seems he has an, multiple open felonies. So we're gonna ask for felony hold.
Okay, what's the address, case number, he has a bench warrant
Yes.
on case number B256670. And that was for, yes.
Defense will be asking for a standard bond.
Okay, he missed trial.
He has, yeah, gonna ask for a felony hold just because he has 4 open felonies. Or, sorry, he has 2 open felonies.
He'll be on the bond hearing calendar next judge for the felony case.
All right, so we'll address it at that point. All right, on the B256670 case. I'm going to set the bond at $1,000. In the new cases. We've got the 2. Okay, it's my understanding that this is here on the misdemeanor cases.
Yes, for,
On the possession of the drug paraphernalia and the trespass.
I see just for this at least, bond, it's just for the trespass is what I'm saying.
Yes, Your Honor.
Okay, so everything else is coming back. All right, so this is.
You lowered the bench warrant to $1,000?
$1,000.
And do you find PC, Your Honor? Oh, oh, yeah.
And there's also a stay away order. He's to stay away from 13690 Southwest 268.
We enter a plea of not guilty, demand discovery, asked set a date for trial.
That's good.
Giovanni Vasquez.
Good morning. Do you speak English or Spanish?
English.
Okay.
All right, because of 1 count of trespass after warning.
State's gonna ask for elevated bond. He has 3 open misdemeanor charges already of similar nature. Or no, he has 1 open trespass. My apologies.
He's got trial the 28th of July.
We would ask for a standard bond in this case.
All right, who's gonna find probable cause and issue?
Receive the social security check.
Okay.
You're asking for elevation?
Correct, Your Honor. Yes, 3 open cases.
I'll elevate it to 750.
Sorry, I thought there was only one open case.
I see a disorderly conduct, a trespass, and resisting without violence, all for 728 trial.
Yeah, 750.
750, thank you, Your Honor.
Okay, there's also a stay away.
Okay.
Okay.
Wait.
18530 Northeast.
If you call,
Hmm?
there's a stay away order from that McDonald's, okay?
Why? That was.
If you get released, just don't go.
Okay, that's fine. No problem. Was
All right,
it?
so call your attorney to put a motion modified bond on. Good morning.
Hello, good morning.
Do you speak English or Spanish?
English.
Okay.
Juan Del Toro.
Yes, good morning.
State's can ask for a felony hold. He has an open felony for controlled substances of possession of controlled substance.
Is that on my felony bond or an already a case?
Can't tell if it's being set for this next bond.
Does he have another open felony?
Yeah, it seems you bench warranted on it.
He'll be on a bond hearing calendar next.
All right. Okay. All right. All right. So there was a warrant. So there's a $500 bench warrant.
It's just for the bench warrants. It's gonna be $500. Your felony attorney can help with the felony bond.
All right, I'll go ahead and set a $500 bond for case before 24563.
And you found probable cause, Your Honor?
The bench warrant, yeah.
Okay. Oh, yes, yeah.
I believe not guilty, demand discovery and asset today for trial.
From 950 Southeast 12th Street in the highway.
We're gonna come back. Okay. Mhm. Okay.
Wilson Castillo Guillermo.
He was relocated, reset for tomorrow.
Okay.
Yeah.
A bank. Louis Abanes.
Relocated, Judge, reset for tomorrow.
Efrain Cabrera.
Refuse court, reset tomorrow.
Cesar Gatan or Gayton.
He's present.
Gaitan.
Okay, Mr. Gatan is present. He's charged with one count of driving the license suspended and one count of reckless driving.
State's gonna ask for
Standard bond.
standard bond, Your Honor.
Defense will be asking for pretrial services. This is his, I don't see any priors at all. And he has informed me that he is on track for getting a good license.
Yeah. Felony grand theft or felony grand theft.
On or Gaten.
Yeah, a second degree felony of grand theft. He has multiple convictions of tampering with evidence, carjacking, robbery, kidnapping.
Okay, I'm just gonna go ahead and set the standard on the TWLS knowingly, which is 150.
350 on it.
And then the reckless driving, which is 150.
I apologize, Your Honor. What was the bond amount for?
Standard.
Okay.
First one, TWLS 150.
150.
And the reckless driving, so 300 total.
Thank you.
I'm sorry, Your Honor. Could you repeat the bonds again? You were cutting out a little bit.
Okay, yeah. Count one, DWLS knowingly 150, which is standard, and count two, reckless driving 150, which is standard as well.
Thank you, Your Honor.
Rodolfo Miguel Torrent or Torrente.
Also, we stand on our pleadings in Mr. Gaetan's case. Mr.
State's just gonna ask for standard bond.
Yeah, there was Mr. Torrent or Torrente. There was a bench warrant for $500 going to appear at the arraignment. The charges were TWLS. I guess that was the only charge.
Yes.
Mr. Torrente needs a Spanish interpreter.
The interpreter is connected, Your Honor.
All
We'd
right.
be asking for the standard bond as well.
La defensa pide fianza estándar.
Does he have priors? Can he get a good license?
I don't see priors, Your Honor.
La fiscalía está revisando para ver si tiene antecedentes.
All I see is just, yeah, that he bench warrant on the DWS knowingly.
I don't see any priors, Your Honor. We asking for pretrial services in this case.
No tiene antecedentes, fianza estándar.
Find probable cause. And I'll just do standard bond 150.
Okay.
Excuse me, Your Honor, I just want to make sure that the charge is that DWLS.
Yeah.
Thank you. Muy bien, para el delito de manejar con una licencia de conducir suspendida, su señoría encuentra causa probable y establece la fianza estándar de $150.
Permiso. El policía, cuando me paró, yo le enseñé toda la documentación de que tenía mi licencia. Había pagado ese día mi licencia.
Okay. Call.
What was the bond again, Judge?
The standard 150.
Torrente?
Yes.
Oh, so you lowered the bond. The bench one was 500.
I'm sorry. I thought the bond was 500. The bond is not 500 in Torrente?
Because I heard 150. The jail card has bench warrant 500.
Yeah, I reduced it to 150.
Okay, Judge. Thank you.
Yeah.
¿Tengo la licencia mía? Si yo la pagué la licencia. Okay.
Okay, Ariel Peralta Racinos.
He needs a Spanish interpreter.
Connected.
Judge should be on your bond hearing calendar next.
I see that. Okay, so we just have the DUI and the no valid driver's license.
En este momento su señoría se va a hacer cargo solo del delito de manejar bajo los efectos y no tener una licencia de conducir vigente.
I'm gonna go ahead and find probable cause, set the standard bond for the DUI at 1,000. Probable cause for the no valid and set that standard 150.
50 or 150, Your Honor.
150.
Thank you, ma'am. Su señoría encuentra causa probable para los delitos que se le imputan. Para el cargo número 1, la fianza es de $1,000 y para el cargo número 2, la fianza estándar de 150.
1,000 and 150. And I'll see him in the felony calendar.
Lo volvemos a ver en el calendario de delitos mayores.
Jose Miguel.
You're gonna come back. It's 150 and 1,000.
Jose Miguel Pinto.
You're going to bond hearing calendar next.
All right, he's got 2 open bench warrants.
Yeah, so we're gonna ask for elevated bond, Your Honor.
Oh, they're new cases?
There are 2 new cases. Oh, then I'll fix it.
Okay.
But you see,
All right.
see it.
What's the full-
3
Okay,
different incidents.
all right, so there's 3
This is
cases.
the bill.
All right, so he has open bench warrants for, here. He failed to appear in front of Judge Ferrer on 124 on a DWLS knowingly and a no valid. He failed to appear in front of Judge Ferrer on 127 as well for the DWLS and the no valid.
That's be asking for a standard bond on both of these.
We're gonna ask for elevated just because he's cases.
Yeah. So what I'll do, right. Go ahead and announce the case numbers. On AJLEFDE, I'm going to keep the bench warrant, the bond at the warrant amount of 1,000. On the no valid, I'll reduce the bench warrant amount to 500.
Can I have the case numbers, Judge?
That is AJLEFCE. And on the bench warrant on AJLELIE, which was the bench warrant on the DWS knowingly, I'll keep that at 1,000. And the no valid AJLELJE, I'll set the bottom out at 500.
You said 1,000 for JE?
Yeah, hold on. No, I just.
It was 500 for JE.
Excuse me, Judge.
Yeah, hold on. All right. So let's go over it again. AGLELIE, the bond amount would be 1,000. AJLELJE, the bond amount would be 500. Again, AGLEFDE, the bond amount, keep it at 1,000. The AJLEFCE bond amount, I'll reduce it to 500. Go ahead and look the new cases. And he's being charged once again with driving while he's suspended and no valid.
I have the only one right now is just the no valid, but yes.
He's driving again.
Maybe we'll probably file a motion to revoke bond or something along those lines, but I mean, we're gonna ask for, once again, an elevated bond, but it sounds like he might be on the next calendar, it sounds like, according to corrections.
Mhm. And with that- No. Okay. Then on the new case, the ALE DC, ALECC8E, which are being suspended. Set the bond at $1,000. No.
We'll be asking for the standard bond of 150.
I'm gonna elevate it to 300.
Thank you.
And the no valid, I'll keep it.
150, you say, for the no valid?
Yeah, and that would be on the ALECC70 case. And I'll see him on bond. Okay, it's gonna take us to Yokel Gomez Rivero.
He has an immigration hold.
Inglés or español? Okay. Mr. Gomez Rivero needs a Spanish interpreter.
Señor Rivero Gómez, se acaba de anunciar que usted tiene una retención migratoria.
Okay, well, first thing I need to advise you is that you do have an immigration hold.
Lo primero que le tengo que dejar saber es que usted tiene una retención migratoria.
And you're also being charged with 1 count of driving under the influence, as well as 1 count of reckless driving.
Muy bien, a usted se le imputa 2 delitos, un cargo de manejar bajo los efectos y otro cargo de manejo imprudente.
Okay, state.
Your Honor, we're gonna ask for a standard hold, or standard bond, Your Honor,
We'll be asking for standard bond as well.
for a no drink, no drive order.
Okay, we'll find probable cause on the DUI AD 07 COE on pose standard 1,000. And on the reckless driving, we'll also find probable cause and enter a standard bond of 150.
I'm sorry, Your Honor, you said 150?
Yeah, that's standard. And wait a minute.
DUI case.
Su señoría encuentra causa probable para el delito que se le imputa de manejar bajo los efectos, le impone la fianza estándar $1,000, así como también encuentra causa probable para el delito de manejo temerario y le impone la fianza estándar de $150.
If they want to close it out.
Okay, and also the state's requesting no drinking, no driving. Okay.
You want to be released.
Y una orden de no bebida, ni beber ni manejar.
All right.
Tu abogada, okay? Call in on teléfono, okay? Tomorrow.
Del
Mañana. Okay.
Escure Ruano.
Here you go. This is the bond, but do not bond it.
Aquí llamo la abogada.
Mhm.
Y le hago una pregunta, ¿por qué el tema de la retención migratoria?
1,000.
You have an ice hold.
Do you need the interpreter?
Yes, Your Honor, but
Yes.
not right now.
Okay.
Right.
Your Honor, we're gonna ask for elevated bond. He has an open felony, Your Honor.
Okay.
Felony hold.
Michael Azubergue,
And he needs the Spanish interpreter.
Spanish interpreter, and he's being charged with driving under the influence. I'm sorry, does he have priors?
No, he has an open felony, Your Honor.
Is he going to be on our bond?
No,
I
Judge,
can't-
Does he have an open felony?
he does.
And F3, yeah, we're gonna ask for a felony hold.
All right, and what is the case number?
F24024914.
You're gonna ask for a hold.
Hearing date is for September.
You asking for a hold?
Yes, yes, Your
All right,
Honor.
I'll go ahead and put a felony hold on F24244914. And
I'm gonna ask for a standard bond.
probable cause for the DUI, standard bond 1,000. And was that the same interpretation?
Yeah.
And we enter plea of not guilty to discovery and set a date for trial. If the Spanish interpreter could interpret all that for him.
Then Jose Hernandez.
I'm sorry? Yeah, he needs a Spanish interpreter. If the Spanish interpreter could interpret what just happened.
Okay, Mr. Hernandez failed to appear for an arraignment.
Your Honor, the Spanish interpreter needs to tell Mr. Alzegueri Renano what just happened.
I'm sorry, but I wasn't aware that he needed the services. So I know what the judge just said, that he didn't appear for arraignment.
No, that was a different charge.
Okay, we're back on, I'm sorry, I thought we had the Spanish interpreter. On Michael Alzegueri Ruano, being charged with 1 count of DUI, in which I found probable cause. I set the standard bond at 1,000. In addition, has an open felony in F2424914, in which I'm placing a hold on that case.
Muy bien, a usted se le imputa manejar bajo los efectos. Su señoría encuentra causa probable y establece una fianza estándar de $1,000. Además de eso, usted tiene un delito mayor abierto, es el F2424914, por lo cual su señoría emite una retención.
Okay.
Ok,
This is tu abogado, okay?
ok. Entonces no tengo con vos para salir, ¿no? No puedo salir con vos. Una retención tengo.
I cannot pay bond, right?
Do you need the Spanish interpreter? Yes. Okay, Mr. Hernandez needs the Spanish interpreter.
Yes.
Okay.
And Hernandez failed to appear at an arraignment and has a $1,000 bench warrant for driving with license suspended.
Señor Fernández, usted no compareció ante el tribunal para la instrucción de cargos, por eso se emitió una orden para su captura y arresto por un total de $1,000 y esto es por el cargo de manejar con la licencia de conducir suspendida.
We'd ask for the standard bond in this case.
La defensa solicita fianza estándar.
All right, the court will find probable cause and set the standard bond at 1,000.
You can bond that.
A
tu abogado.
Su señoría encuentra causa probable para el delito que se le imputa y establece la fianza estándar de $1,000.
Driving with license suspended?
Yes. They lowered them last year.
Oh.
Up to you.
No, I'm gonna keep it as the amount of the bench warrant. 1,000.
Mantengo la fianza al monto que lo establece su orden de captura, $1,000.
You said,
Which used to be.
1,000 or 2,000?
$1,000.
Yeah.
10% of this. 10% of this.
Was it 1,000 or 2,000 for Hernandez Nelson?
I believe Your Honor said it as 1,000.
1,000.
1,000.
Kept the bond.
Call him to abogado.
Mm.
Okay. And the public defender stands on their pleadings.
I got Nelson Hernandez.
Renell Munoz.
I have Munoz. Munoz?
He has an immigration hold, Judge.
That was Munoz? That was a Nelson?
Calling Munoz, Ronell Munoz.
Your Honor, I apologize. The inmate that was just in here was Mr. Munoz. We did not have Mr. Hernandez. We need to recall Mr. Hernandez.
Well, we need to recall Mr. Munoz because he's being charged.
And Mr. Munoz.
Bench warrant for $3,500.
We need to get Mr. Munoz back in here.
Okay. No, not on the traffic one. All right, where is Nelson Jose Hernandez?
He's coming, Judge.
Okay, no, we have to bring Munoz back. This is Mr. Munoz. We do not have Mr. Hernandez yet.
All right.
That's Mr. Munoz.
What's your name?
¿Cuál es su nombre, señor? En el micrófono, por favor.
Ronald Muino Mendoza.
All right. I don't know where the Mendoza comes from. I don't have a Mendoza added to this. Corrections, is this Ronell Munoz?
Yes, Judge.
All right. All right. He was, there was a bench warrant for $3,500 for failing to appear on a no driver's license charge.
We would ask for a standard bond for a no driver's license charge of $150.
He also has an immigration hold.
All right. First of all, the interpreter needs to advise the immigration hold.
Ok, Your Honor. Muy bien, señor. Su señoría le informa a usted que tiene una retención migratoria. Además de eso, hay una orden de captura y arresto en su contra por un valor de $3,500 por no haber comparecido ante el tribunal para responder al cargo de manejar sin una licencia de conducir.
Judge, would be asking that it be converted into the bond amount for the video, the bench warrant. So we want a $3,500 bond.
La fiscalía está solicitando que el monto se cambie a lo que es por manejar sin una licencia de conducir, que son $3,500.
We again would be asking for a standard bond.
150.
I'm gonna set 300. I'll elevate the bonds a little bit. Yeah, $300.
Public defender stands on their pleadings.
Fianza, $300.
All right, so now we need Nelson Jose Hernandez.
Okay.
Llevó
And call la abogada. Mhm. Hola. Do you need English or Spanish?
Whichever.
Español?
English is a little bit better.
Okay, well, we don't need the Spanish interpreter.
Okay, what is your name, sir?
Nelson Jose Hernandez.
All right, sir. You failed to appear in court on 6/2/2025 on a driving while license suspended ticket. Judge,
Yes.
$1,000 bench warrant.
Yes. I was.
Can you get his license?
I let them know. Never took me.
Mr. Hernandez advised me that he was at Metro West at the time that this bench warrant was issued. Not a willful failure to appear. We would ask that.
Can corrections verify that?
Verify what?
That he was in custody on 6/2/2025?
He was booked on 6/14. That's all we have, Judge.
Okay, there's no way to see if he was in custody on 6/2/2025. I find that hard to believe.
The state can look it up, Judge. We don't have it.
I was in custody from April all the way down.
You were taken into custody in April?
Yes.
Okay, I need somebody to verify this.
Trying to look it up on my computer now, Judge. What were you in on?
Should be, let me see here. Sin, right? Oh, no, wait, no, that's a no. I don't have the jail number. Oh, no, I do. 250 142 184.
It was booked on June 14th, Judge.
That is the new jail number. I'm looking for the old one.
Okay, there's no way to verify whether or not he was in custody on 6/2?
Yes, Your Honor. If you give me 1 second.
Do you need the OJO number?
I have it.
Okay.
Okay.
He was booked on 4/18 and released on 6/5.
Say that again?
He was booked. Yes, he was booked on 4/18, April 18, 2025, and released on June 5th, 2025. So that would be after the warrant was issued on 6/3. So he was in custody. This is what CJIS is showing me. And I have that case number or that jail number if anybody needs it. We asked that he be ROR'd on this. So it was not a willful failure to appear.
I don't.
Would you like the case number or the jail number for that?
Yeah.
250 134 328.
We're still gonna ask for the,
He was booked on 4/18, released June 5th.
All right. I'm gonna ROR him.
And public defender stands on their pleadings.
Yeah. All right.
So I should be home later today.
All right.
Thank you so much.
Make sure you show up to court.
I will. Yes, ma'am.
Good luck to you. Percival Quintel Spivey.
Ivy, good morning.
All right, Mr. Quintel Spivey is charged with driving license suspended. Standard.
yes, standard, Your Honor, sorry.
All right. We'll find probable cause. I'll go ahead and just issue a standard.
Yes. We've asked for the standard one.
Yeah. 150. All right, that's going to take us to Kenneth Bernard Phillips.
And public defender stands on their pleadings for Mr. Spivey. Okay, good to go.
Kenneth Bernard Phillips. This was reset from yesterday.
That's correction. Did we have them?
Corrections, do we have Kenneth Bernard Phillips?
No, we don't.
What number is that?
What number is he, Marcus?
It was reset from yesterday.
It was a reset from yesterday.
We don't have him.
No, okay, so we'll be reset for tomorrow. All right.
That was, I'm sorry, Your Honor, could you repeat the name?
That was Kenneth Bernard Phillips. It was a no valid driver's license. AK8C91E. Reset. That's it.
Your Honor, good morning again. This is Joanne Hennessy. If I could be excused, I was just here for the jail arraignment calendar.
It'll be good to see you. Have a great rest of the day.
Thank you. Good day.
We do. They are really good.
Yeah, thank you so much. All right, bye.
Is that clerk either the state from Alvarez and also? I was like, where's Gordon? The consensus around county court from Marquez. This time.
If I could steal you, I would come over here. I have to know support people. Do you know Willie Carrick? Hello. How are you? How are you? I'm fine. Scott for me today. Yeah. Wait. Yesterday. Okay.
Oh, hey, we need to get the stay away orders and put them, give them. Okay. I'll see you Monday, tomorrow.
Good morning, everyone. Assistant Public Defender Alejandra Preciado. I'll be covering felony bonds.
Contact my supervisor.
I want to.
I'm the only guy on this side. On my end.
We had like 5 bonds. Well, bonds. And Friday, they were stretching all, so there were kids of those. Right away. Yeah, I love it for a while. No, I usually don't get them for that.
Consider yourselves lucky because I've heard stories.
I've heard stories too.
Those stories that they scared.
Oh my God. Where's my area? Today. Morning, yeah. You guys ready? I'm ready. Are you guys ready?
We're just getting out to say we don't need to stay away. Up the top. But that would go on the bottom. If it's there.
Well, you should be ready, Your Honor, in a few minutes. My apologies. 824575.
I had nobody. I heard that, I heard nobody, Oh, Sammy.
Judge? Sorry for interrupting. I know that there's some matters that are being addressed.
Rise and raise your right hand.
Todos pónganse de pie y levanten la mano derecha.
All rise and raise your right hand. Do you swear for the testimony about to give you the truth, the whole truth, and nothing but the truth, Heather?
¿Juran o afirman que el testimonio que van a dar es la verdad, toda la verdad y nada más que la verdad? Díganlo, juro.
Yeah, you can sit down. I wasn't sure if they were video. Okay, first case on calendar, Sammy Rodriguez.
Your Honor. Good afternoon, Assistant Public Defender Alejandra Preciado. Will we be appointed on all of the felony cases as we were this morning on county cases?
Yes. Provisional.
Thank you, Judge. And then this is number 40.
The 40, Sammy Rodriguez.
Refuse, Your Honor. Corrections is letting me know. Reset tomorrow.
Okay. Okay. Reset tomorrow? Yeah, tomorrow's the 16th. Okay, wait.
Your Honor.
All right, Tabrea Bell.
Judge, I'm sorry, are we going to the the order that we were with Sammy Rodriguez, number 40.
Okay, starting back at number 1.
The thing is, we're calling out of.
I was told that we just needed to take that one out of turn.
All the way back.
All the way back?
Yes, Judge.
Well, nobody said that, so.
It's for the particular jail, Judge. So it would start on 40.
Okay, Rana, I put it out for you.
Yeah, but I put it back because I thought they wanted to take one person out of her.
And Sammy Rodriguez refused. Okay.
Sammy Rodriguez refused, reset for tomorrow.
Alfred Nippon.
Mr.
Refused.
Alfred, he also refused, reset for tomorrow.
He refused again? Okay.
Okay, refuse, reset. 616. Frank Stabili.
Mr. Bill refused, reset for tomorrow.
All right. Kobe Lavender.
He's present before the court, Your Honor. I have argument.
Okay. Mr. Lavender is charged with first-degree attempted murder.
And Judge, as the arrest form reads, he is already in custody on F-25-11-980. This is an added charge. And the one that he's already in custody occurred per the arrest form at 2054. This new arrest form dropped at June 10th at 2000 hours. Judge, as to that, I would be asking that this court, he doesn't have any violent priors in terms of his local priors. I'm asking this court set a bond.
You know, this is for first degree murder. We're gonna hold SW held no bond.
Can you go ahead and review the A form? Okay, subject was holding the victim. His torso was over the balcony. Subject said, "Bitch, I can kill you," and then repeatedly stated, "Go ahead, bitch, jump." Yeah, what else? What else do we have? Never intention of either pushing her over the side or having her jump off the balcony. So she grabbed onto another female that was on the balcony with them. The subject again repeated, "Go ahead, jump," after the defendant loosened his grip slightly. And the victim was able to maintain her footing on the balcony. Right, Mr. Lavender is being charged with first-degree attempted murder. No bond.
No bond.
No bond.
And then there is a stay away order with that, Your Honor.
And there'll be a stay away order from the victim KF. Yasnel Albert Terrace.
This is also an added charge.
Is Mr. Albert Harris there? Refused yesterday, I guess.
Battery by detainee. He's here, Judge, coming up.
With the services of the Spanish interpreter.
Connected.
All right, so Mr. Albert Harris is being charged with one kind of battery by detainee on a visitor.
Or other detainee.
Both the defendant and the victim are inmates at Metro West.
O sea, se le imputa agresión de un detenido a otro detenido. Según las alegaciones, ambos son reclusos en Metro West.
We're gonna ask for elevated bond. He has also other outstanding. I mean, he's being held right now, but we'll ask for felony bond or felony. Yeah, felony bond.
Judge, if I may be heard, this is a third-degree felony. He doesn't have any violent priors. I'll leave the Spanish interpreter interpret.
Yes, domestic violence injunction, battery, pretrial regulation, violation of pretrial, I guess, and then stalking aggravated, again, breaking an aggravated stalking court order.
Judge, those are cases that are pending and open. He doesn't have any violent convictions. I'm asking this court to set a bond, thinking about the four corners of the arrest form that are here before this court. There's no audio or anything, so that there's a full understanding of what took place. I'm asking for a monetary bond to be set on this case of $1 because he is being held on the other cases.
La fiscalía dice que no deberían darle fianza debido a que usted tiene antecedentes de delitos violentos. Lo que dice su abogada es que estos delitos están abiertos y pendientes, que por ende no tiene usted ninguna condena por delitos violentos. Pide que se base en la totalidad del atestado de arresto y que se establezca la fianza a $1, ya que usted tiene retenciones de delitos mayor en otros cargos.
He's got anger issues. I'm gonna go ahead and find probable cause. And I'm gonna set the bond at 5,000.
Su señoría encuentra causa probable y establece la fianza en $5,000.
Okay. Emmanuel Batista Rostran.
Defendant refused, Judge.
Okay. Seth Bars.
Bars is ward D reset for tomorrow.
Two cases. Cesarius Jamari Jackson.
Mr. Jackson also refused.
Judge, I'll waive his presence. May I be heard?
Mr. Jackson?
Yes, Your Honor. I have argument.
All right, go ahead.
As to the four corners of the arrest form, there's no indication on how and who committed this. There's indication of CCTV, but there's nothing as to it being on video or corroborated by anyone, Judge. So I'm asking that this court release this outright on this particular case and the other case that's coming up because it's the same arrest form.
We're going to ask, we have a stay-away order for this. We're going to ask for let's see here. Standard bond.
You know what I'm gonna do? I'm gonna reset both and you can make your argument tomorrow when the judge calls them.
Okay.
Refuse, reset, 616.
Are you gonna get a stay order?
I'm resetting everything tomorrow. I'm resetting everything tomorrow. Okay. Donnie Tarpley.
This was reset from yesterday, Judge.
Is he there?
I believe it was reset for argument as well.
Tarpley is refused, but we still want Judge Walls.
Reset for tomorrow. William Walls.
Reset as well for tomorrow.
Right. Hmm. Samuel Day.
Day also refused.
Just gonna ask for a elevated bond.
You refuse.
For Samuel Day.
Or Orlando Castillo Chiang.
The rest of the individuals I'm being told refuse. They would all be reset to tomorrow. So from 51 through 54.
Reset. That 616. Right. Janelle Jarrington Jarquin has refused.
Refused.
Marquise Armstrong has refused.
Yes, Your Honor.
Correct.
Yes.
Defender refused. Reset for tomorrow.
And the last one, Jordan Nunez. Jordan Alexander Nunez.
Refused. Reset for tomorrow.
Refused. Reset. Yeah. I'm gonna start with there again. Starting back at the beginning, Debrea Quintavia Bell.
It's present before the court.
Okay.
Judge, Mrs. Bell is a V Fox. She's out on probation on F22 5428 Alpha.
225428.
Your Honor, we're gonna ask for no bond.
Well, let's go ahead and put the
It's on the
hold on the other.
Judge, I have argument as to probable cause.
Okay, but I'm addressing the open felony on it. All right, and in this case, she's being charged with one count of armed robbery with a firearm or deadly weapon.
May I be heard?
Give me a minute. Okay. All right, go ahead.
In the reading of the four corners of the arrest form, it indicates that the co-defendant is the individual that's seen holding a firearm. At no point on the four corners of the arrest form does it indicate that it's Miss Bell, Judge. Mere presence enough isn't sufficient, and that's defense's position. I'm asking that this court release her outright.
Your Honor, it's not that they just mere presence. She walked with the co-defendant over and stuck the gun in her face. She was right there during the commission of this armed robbery. To say she's not an accessory, at the very least, co-defendant and threatened the victim's life. We're gonna ask for no bond.
And Judge, in the arrest form, there's no indication that she gave instruction to the individual that pulled the gun on the alleged victim. There's no indication that she incited her, coerced her, or did anything. I again stand on mere presence is not sufficient alone, sorry.
Not that she was just a bystander. She walked with the other co-defendant to the woman and made threats. The defendant was threatening the victim's life while this was occurring.
Okay,
Yeah, and they fled the scene together. I mean, this is really two individuals committing armed robbery against this victim, even by the four corners of the arrest form. Yeah, they're acting in concert.
Got the gun, the co-defendant pointed the firearm at the victim, and the co-defendant forcibly took the purse.
But it states that the defendant was the one threatening the victim's life while this was struggling, and they went.
Is that an armed robbery?
They went together in concert, Your Honor, to this person and fled together.
custom?
Judge, I'm asking this court release her outright. There's other cases, accessories, everything like that. The state keeps reiterating something, but the four corners of the arrest form does not establish that she was the one that acted alone, acted at the behest of somebody, or was instructing somebody else.
Your Honor, at the very least, we would like to have set a probable cause hearing for tomorrow.
I'll go ahead and reset this for a cause hearing tomorrow. All right. We reset. Ariana Montano. Ariana Montano.
Mrs. Montana refused, reset for tomorrow.
Maritza Ubey.
Present before the court.
Ms. Ubey is charged with 1 count of aggravated assault with a deadly weapon.
State's gonna, we're gonna ask for a standard bond at this point.
Your Honor?
Violent prior convictions.
Judge, as to the four corners of the arrest form, there's indication of incoherence. I'd be asking that this court release her to pretrial services. The four corners bring into question the intent and the mental state at the time.
Wait 1 moment.
It's 5.
And Your Honor, the four corners state that the victim advised that the defendant threatened her with a silver serrated knife. Just by the four corners, we're gonna say that, you know, there is probable cause to say that there was an aggravated assault with a deadly weapon, and we're gonna ask for, once again, standard bond.
Okay. Isn't there a it's just Verdi's mental health court, right? Oh,
I don't know if this, I mean, it seems that it was already in, you know, but I don't know if there's anything that really rises to it being kind of seen as a mental health court or, you know, an issue of mental health.
All right. Well, this is what I'm going to do. I'm going to go ahead, based on four corners of the complaint, find probable cause, issue the standard bond amount at 5,000. If she has issues, then once that gets into the division, it's my understanding that Judge Verdi does have some sort of mental health program. So perhaps we could be put into that division. In addition to setting the standard bond, I am going to enter a stay away order. Ms. Ube is to contact either directly or indirectly with the alleged victim, Albany Lawson.
Are you denying my request for the pretrial services as an alternate even?
Yeah, no, I've been told that she doesn't qualify.
On what grounds?
Okay, it's going to take us to Milagros Castillo.
This is an added charge.
I have argument whenever the court is ready. And it will apply for the 3 new added charges. Because it's the same statute.
We just addressing the added charge? Or we're addressing all three? No.
Your Honor, I see.
Already in custody. Okay, so she's being charged with 3 additional counts of retail theft in the 3rd degree. Okay, all right, what would you like to say?
Yes, pursuant to 812.0158F, the 4 corners of the arrest form don't indicate and meet the date range that statute requires as to F25-12386, F25-12385, and F25-12384. Based on that, and that being the statute that they relied on the arrest form, I'm asking that this court find that there is no probable cause and release her outright on these 3 cases. She's being held in the alternative. I'm asking for a $1 bond.
I'm sorry, wait, we couldn't hear you?
Yes, Judge. What part?
All of it, to be honest with you, I apologize.
All of it, if you can put up your volume.
The state of Florida, through their officer, arrested this individual and charged her with 812.0158F. The reading of the statute requires that there be a meeting of time. In reviewing that statute and the arrest forms this morning, the officer doesn't have that information in the 4 corners of the arrest form. As such, I'm asking that this court does not find probable cause for this 3rd degree felony as printed. If this court is inclined to find, it should be a petty theft county case, not a felony. Just reading the statute and what it requires.
Right, how would the state like to respond?
Your Honor, it states on the arrest form that this defendant was also, the A form references 2 other petty thefts that occurred within 2025. And yeah, Your Honor, we would like to ask at the very least that there's probable cause hearing tomorrow, so that way we can bring in the officer to kind of explain any discrepancies that are in the A form.
Judge, you can find probable cause for a misdemeanor lesser, and the state of Florida can look at their cases and evaluate if they're going to upfile at a later time. I don't find a need, all due respect to all of the parties that are present, for us to reset this.
Yeah, we're gonna.
I'm saying, Judge, that if you're gonna find, you can find petty theft, just not for the felony as charged on the arrest form right now.
And just because that might be true, that does not mean that I think there's sufficient grounds to have a probable cause hearing.
You know, I'm going to reset this, roll this over tomorrow for a piece.
Thank you, Your Honor.
Yoani Salgado.
With the services of the Spanish interpreter.
Okay, and this
Connected.
Okay, so she's got an 18 on F257427.
Yeah, state's gonna ask for a standard bond.
Okay, and then she's being charged with 1 count of possession of cocaine.
La fiscalía solicita fianza estándar y a usted se le imputa tenencia de cocaína.
I'm asking for pretrial services. She doesn't have any priors. And just reading the arrest form, there's a motion to suppress, just given the fact that she was searched.
Talk closer to the microphone.
My pleasure.
Okay.
The arrest form, as it reads, there's a motion to suppress. I'm just letting the state know ahead of time. As to that, I'm asking that this court set an alternate pretrial services, given the fact that she doesn't have any priors or convictions.
Dado que usted no tiene ni condenas ni antecedentes y además en el atestado de arresto se dice claramente que se va a entablar un recurso para suprimir evidencias, pide que le pongan a usted el programa Pretrial Services y de manera alterna una fianza.
Your Honor, she has another open case for this same charge.
Yeah, I'm being told with the AC that she cannot be enrolled in pretrial services. So I'll go ahead and just set the standard bond at $2,500.
Would you set a reduced monetary bond, Judge?
Judge, Mrs. Sagano also has an AC no bond.
AC, that's correct.
Yeah.
On what case number?
F257427.
So, yeah. Huh?
Right, but that was the case that we addressed earlier. So that one's AC no bond. I'm asking that this court on the case that's before this bond hearing, F25-12359.
I mean, if it's on the AC no bond, I mean, I guess we would ask for felony bond or felony hold.
No, I put a hold.
Yeah.
Yeah.
She's in custody on the AC no bond already.
I'll do the reduced. 1,500.
And did you find probable cause, Your Honor?
Yes.
Muy bien, entonces, ya que usted tiene una orden de captura y arresto sin fianza en la causa F257427, su señoría le va a dar a usted una fianza reducida en esta causa de $1,500 y encuentra causa probable para el delito que se le imputa.
Susan Diaz.
She's present before the court.
Okay, Ms. Diaz is being charged with 1 count of possession of a controlled substance, crystal meth, and 1 count of possession of drug paraphernalia with the intent to use.
She's gonna ask for standard bond.
And she's eligible.
Sorry, she's gonna ask for standard bond.
Judge, as to the 4 corners of the arrest form, there's no indication that the officers had reasonable suspicion to first search and stop her. She was the passenger, not the driver. Second, I will be asking that this court either enter pretrial services given the fact that she doesn't have any priors, or consider a reduced monetary bond.
Your Honor, it seemed by 4 corners, I mean, they had probable cause to pull over the car because of a broken taillight, and the packages that were found were within the constructive possession of the defendant, even though that they were in front of her in the passenger seat. She was in constructive possession of them. So we think that creates a probable cause.
Allegedly consent. All right, what I'm going to do, I'll go ahead and find probable cause. I'm going to allow her to go into pretrial services with an alternate bond. And I can, the alternate, I'll reduce it to 1,500, count 1, and 500. Wayna Lovett.
Mrs. Lovett is Ward D reset for tomorrow.
D.
State's gonna ask for standard bond, Your Honor.
Who's Ward D?
Huh?
She was Ward D.
Oh, my apologies.
Okay. Israel Vasquez Quinteros.
He's present before the court.
Mr. Vasquez Contreras has a hold for ICE.
We need the services of the interpreter.
Roger that.
Okay.
Your Honor, who is this?
This is Israel Vasquez Contreras. Okay, Mr. Contreras, I need to advise you that you do have a hold, an immigration hold from ICE.
Yes, he has an ICE hold.
All right.
Señor Contreras, Vázquez Contreras, tenemos que informarle que usted tiene una retención migratoria.
And you are being charged with 1 count of burglary, armed burglary, 1 count of carrying a concealed weapon, and 1 count of disorderly conduct.
A usted se le imputa allanamiento a mano armada, portar un arma oculta y Your Honor, would you mind repeating the third charge, please?
Disorderly conduct.
y conducta caótica o desordenada o alteración del orden público.
Yeah, it's just, for, Israel, we're gonna ask for, no bond at this time.
En ese momento la fiscalía solicita que no le den fianza.
Yes.
May I be heard? May I be heard, Judge?
Yes.
Oh, sorry, I was waiting for your instructing. I apologize. In relying on Dorolas versus State 747 Southern 2nd 368, it's a Florida Supreme Court in 1999. The question is whether somebody can recognize the item for the concealed nature of it. Here, the arrest form indicates that from the beginning, everybody was able to recognize that it was a knife. As such, he wasn't carrying a concealed weapon and or firearm. Secondly, Judge, there was no indication that there was any disorderly conduct or stop of business. Annoyance alone is not sufficient for a disorderly conduct. As such, I'm asking that this court not find probable cause as to count 2 and 3. I'll remain silent as to count 1. However, I will say there's no indication that the business entity was closed or closed off for visitors.
Su abogada acaba de citar jurisprudencia del año 1999 diciendo que básicamente el cuchillo que usted portaba no estaba oculto, ya que todo el mundo se pudo dar cuenta que usted tenía un cuchillo. Así que se opone al cargo 2 que le imputan y al cargo 3 porque tampoco usted hizo alteración del orden público y se mantiene en silencio con respecto al cargo 1.
Yeah, Your Honor, it seems that when he actually entered the area, he concealed it in his waistband. Additionally, he was not allowed to enter or remain at the establishment because he was an ex-employee who was terminated. So he's already breaking and entering by returning to the establishment. I mean, there's clearly, I think, probable cause to find that the defendant has committed burglary and armed robbery and as well as count 2 for concealed carry.
What are you asking? Count 1?
Yeah, and I think these 2 kind of come into account for creating the basis for count 3 for disorderly conduct.
But bond-wise, what are you asking for count 1?
Oh, we're asking for no bond, Your Honor.
All right, based on the review of the A form, the court does find probable cause for counts 1, 2, and 3. Count 1 will be no bond.
Yep.
States file the pretrial detention.
And we did, Your Honor.
There's, okay, that'll go from count 1 to the bond.
Judge, did the state file a motion?
And that has been filed. I'm gonna go and grant the state's request. And there will be an order issued. Our location is 1116 Ocean Drive. Maybe
Your Honor.
count 2. What are you asking for count 2?
Elevated bond, Your Honor.
What are you asking?
$2,000. And then for 3, we can do the standard 150.
Okay, so I'll go ahead and enter a $2,000 bond for count 2 and count 3 and 50.
Your Honor, I just want to make sure that the state has filed a pretrial detention motion.
Yes, they have.
Thank you, ma'am. Muy bien, señor. Su señoría, luego de haber leído la totalidad del formulario del atestado de arresto en su contra, encuentra causa probable para los delitos que se le imputa. Y con respecto a la causa 1, establece no fianza. Además, la Fiscalía ha entablado un recurso de detención preventiva. Usted se queda detenido hasta que se lleve a cabo una audiencia. También su señoría ha emitido una orden de alejamiento. Usted no puede acercarse al local ubicado en el 1116 de Ocean Drive en Miami Beach, Florida, 33139. Con respecto al cargo 2, le va a poner una fianza elevada de $2,000 y el cargo 3, fianza estándar $150.
Fernando Senate, o Senate.
He's present before the court.
Okay, Mr. Senate is out on bond on F244337.
Hey, we're gonna ask for a felony hold, Your Honor.
Court will put on hold on that case. And on this case, he's being charged with possession with intent of controlled substance. That's Xanax
I have argument.
of controlled substance, oxycodone, and resisting without.
Resisting without, Your Honor, we're gonna ask for elevated bond. For these cases, he has, or for these charges, he has multiple convictions and similar charges, including resisting without violence, selling drugs, it kind of goes on, and these are quite a history. I mean, while some of them are more recent, are less recent, I think the history still speaks for itself.
Okay, let me hear from the public defender, please.
Yes, Judge. And looking at the ones that are actually convicted, I see burglary and theft cases. So I would just ask this court to take those into account. I understand that somebody may be arrested, but if they're not convicted, I would argue that you shouldn't take that into account, Judge. In terms of this particular case, F25-12396, the arrest form does not establish intent to sell in any way. It just says mere possession. There's nothing about cutting agents, baggies, money. Just because somebody is facing a charge that happened at a different time doesn't mean that they're out there committing the same ones if you don't find the evidence of it, Judge.
Your Honor, it clearly states that there's a lot of pills in these, and that would, essentially equate to an amount that would not be reasonable for personal consumption. And it's clear that, based on them being also just in the car, like in the center console, I think it creates probable cause that it was probably with the intent to sell. Additionally, I'd just like to make note once again, he does also have an open felony.
And Your Honor, if I may be heard, this officer is not a doctor. There's no indication that he has any medical background to be able to say a person that gets prescribed this doesn't have any of this amount.
I mean, I can find probable cause on possession,
Give me one moment, Your Honor.
but I don't see anything regarding the intent to sell. So probable cause for possession on count 1 and 2.
And that would be the third-degree felony?
Yes. And what is the standard number?
Standard for third degree
Yeah.
misdemeanor or
Felony.
third degree felony is 2,500 without violence.
I could do 2,500 count 1, 2,500 count 2. And the resisting without, is that 500? 500. Okay. Got it. 25, 25, and 5.
And Your Honor, can you put a felony hold on this? My apologies.
Yeah, there was a felony hold.
Okay.
I announced that in the beginning. Gosh, I feel like I'm at home when nobody listens to me.
I am so sorry.
That's okay. That's okay.
Making sure.
Oscar Omar Maldonado Dominguez. All right, Mr. Maldonado Dominguez is charged with 1 count of battery on a police officer for correction.
With the services of the interpreter.
Interpreter?
That's correct.
Oscar Omar Maldonado Dominguez.
State's gonna ask for a standard bond, Your Honor.
Okay, he's being charged with 1 count of battery on a police officer, corrections officer, and firefighter. And I still need the interpreter to interpret for me, please. Madam Interpreter, are you there?
Yes, Your Honor, I'm connected.
Okay, all right. This is Oscar Omar Maldonado Dominguez, and he is being charged with 1 count of battery and a police officer, corrections officer, or firefighter.
Ese es el señor Oscar Maldonado Domínguez y se le imputa un cargo de agresión a un agente de la ley o un agente correccional o bombero.
Oh, yeah, sorry. Just once again, we're gonna ask for standard bond.
La fiscalía solicita fianza estándar.
Armed Miami-Dade Transit Security Guard.
As to the arrest form, there's no indication that this individual was uniformed to let this suspect that was arrested know that they were working in transit. As such, I'm asking that this court release him outright. He doesn't have any priors.
Su señoría, en el atestado de arresto no se lee de que la persona estaba llevando uniforme, así que el sospechoso no sabía que se encontraba trabajando, por eso le pido, por favor, que lo ponga en liberación inmediata.
Defendant out of the metro station. Jump the canisters again.
Your Honor, it doesn't necessarily state, but it does say he was on duty at the time of the incident. And from the actions that the transit officer was taking, I think it's quite clear that he was acting his duties by trying to prevent the defendant from jumping the kiosks.
Su señoría, si lee el atestado de arresto, se lee claramente que la víctima se encontraba en el ejercicio de sus responsabilidades o sus deberes laborales, evitando de que él saltara el kiosco.
Yeah, transit security officers don't like go undercover. I mean, they're gonna be wearing their uniform. Your Honor, he was on duty.
Además, los agentes de tránsito no están encubiertos, ellos siempre llevan el uniforme, así que se encontraba ejerciendo sus labores.
Is he eligible for trial or no? He has no priors?
Checking again, Your Honor. I did not see priors. A moment.
In my review of the case, no, Your Honor.
Right, Your Honor.
All right. What is it going on? All right. What I'm going to do is I am going to find probable cause, but I will release him through pretrial services with an alternate bond of $5,000.
Encuentro causa probable para el delito que se le imputa, pero lo voy a liberar bajo la supervisión del programa Pretrial Services o de lo contrario paga una fianza de $5,000.
And that's going to take us to Mark Taryn Glover. And Glover charged with possession of a firearm, weapon, ammunition, possession by convicted felon.
The state's gonna ask for elevated bond. He has multiple priors, including. Yes, state's gonna ask for elevated bond. He has long rats with prior convictions.
May I be heard?
Go ahead.
As to the convictions, the most recent one I see, Judge, they're all dating to back 2011, 2012. There's nothing that has been recent. In the reading of the arrest form, there's no indication that the police was called over about this individual threatening or doing anything. It was a pretextual stop that would be defense's position. And then they found an item on this individual. He wasn't bothering anybody. Nobody had a be on the lookout for probable cause by any 2ID. And the way that they're describing this knife on the arrest form, Judge, it's not even used or waved towards the officers. It's a survival style knife that was in the arrest form as stated, Judge. There's nothing else.
Your Honor.
In terms of the prior convictions that he does have in his priors, in my review of the local ones, there's nothing that is Violence, I do see a robbery, but that was dismissed with prejudice in 1999.
Your Honor, I mean, to the defender's probable cause argument, they violated county ordinance, and when they approached, the defendant gave consent for the officer to search the backpack, and that's when he came across the weapon. I mean, that seemed to the weapon was come across lawfully.
Yeah, it does indicate a verbal consent. What is the
Your Honor, we're gonna ask for $5,000. Standard 35.
75.
Oh, 75. Oh, so we're gonna ask for, yeah, right. We're gonna ask for 10,000, Your Honor.
I'm asking for a reduced monetary bond, alternate pretrial services.
Yeah. The pretrial.
The state would object to pretrial services.
Hey, where do you see a local ordinance being violated? You made that representation to the court. What page of the arrest form so that I can know?
It's County Ordinance 24. Yeah, seems Deputy Rael and Deputy Estrada, as well as Deputy, yes, observed multiple males on the north side of the gas station, drinking within 100 feet of the gas station. That is a violation of a local ordinance and drinking in public. So when they approached, they asked if they could search their bags, and the defendant gave verbal consent.
Judge, there's nothing that indicates that these open containers were alcohol. As such, the local ordinance is not met. I go back to my first argument. There was no probable cause or arrest.
Your Honor, I think it's quite clear that they wouldn't be citing them, for the citation if it was, 2 liters of Sprite. It's very clear that they meant alcohol.
Yeah, I'm gonna, on probable cause, I'm going to go ahead and set the bond. The standard 75.
Your Honor.
75. I'm just gonna do the standard bond 75.
Are you denying my request to set a reduced monetary bond and pretrial services?
Juan Del Toro.
Judge, what was the bond for Glover?
7,500. Juan Del Toro. Del Toro in charged with possession of a controlled substance.
The services of the interpreter.
Madam Interpreter, this is Juan Del Toro, and he's in charge with 1 count of possession of a controlled substance, methamphetamine.
Señor del Toro, usted se le imputa tenencia de una sustancia controlada, sospecha de metanfetamina.
Did I already interrupt you? Yes, you did. Okay.
And Judge, the state would be asking for a standard bond of $3,000 on this case. The defendant was picked up on a bench warrant for petty theft. This states for the record.
I think we might have already addressed the bench warrant.
Yes, this morning in county.
Yeah, so it should be.
It's just the 3rd-degree felony, and I have an argument.
Okay.
Constructive possession, there's no indication that he had knowledge or constructively possessed the items at or near his person or at an arm's length, as the law requires. As such, I'm asking this court enter pretrial services, alternate reduced monetary bond.
La Fiscalía solicita una fianza de $3,000 en su contra debido a que usted fue capturado por una orden de captura en su contra debido a un caso de hurto de menor cuantía. Lo que dice la defensa es que posesión obstructa no quiere decir que usted tuviese conocimiento de lo que había o que esto estuviese a una distancia, a brazos de distancia de usted. Por eso solicita que lo pongan bajo el programa Pretrial Services y que le den una fianza reducida.
I do not know how the defense claims that this is within arm's range when the A form clearly states that during the tow inventory of the vehicle, they identified this small clear plastic baggie containing suspected crystal meth. between the driver's seat and the center console. That is within arm's reach of a driver.
The officer didn't put that, Judge. I don't want to make assumptions or conclusions that could be made in front of the jury for the jury to determine.
Okay, what I'm gonna do is I will, make pretrial services with an alternate bond. of 25.
Any found probable cause, Your Honor?
Excuse me, Your Honor, is pretrial services with an alternate of how much?
25, yes, 2,500.
Thank you, ma'am. Muy bien, señor. Su señoría encuentra causa probable para el delito que se le imputa, pero lo va a liberar bajo la supervisión del programa Pretrial Services o de lo contrario paga una fianza de $2,500.
Leone?
Judge, Mr. Leone is out on felony bond F252115.
He refused. I was let know that he refused, so reset to tomorrow.
Okay,
Let me know over here. Do they have? She let me know. Judge, we're just triple checking that Mr. Leon did in fact refuse. One moment, please.
Judge, Mr. Leon refused. He also has a felony hold.
Okay. I'll reset that for tomorrow, and he's got the hold for the felony. Raymond Moore? Is that Mr. Moore? Mr. Moore is being charged with a battery, a person 65 years of age or older.
And the state has a stay away order for the court.
ASA Hunter Wells, for the record, we're going to ask for an elevated bond of $5,000.
Judge, I have argument whenever the court is ready.
What would, Madam Public Defender, what would you like to say?
Yes, Judge. The four corners of the arrest form do not indicate or meet the prong that this individual is 65 years of age or older. There is no date of birth, as would be required for the statute. I understand that it reads at a particular housing. However, the arrest form does not indicate the date of birth. I'm asking that you release him outright. And if you're going to find something, Judge, it wouldn't be a felony 65 years or older. It would be another type of battery. I would argue simple first-degree battery.
Your Honor, if the public defender would just continue reading on the very next page, it states that the victim's birth year is 1938. That is most certainly over 65 years.
What page is that? If that's the third
page, it states that yes, it makes it very clear that the victim is over 65 years of age.
Judge, do you have that on your arrest form as to the date of birth?
The allegation I have is the victim is over the age of 65.
No date of birth though, as to the year that, because I don't see that. I know that the state has a more complete, more pages, but the 2 pages of the arrest form that are for the bond hearing don't include that.
It might do the work mark of the law, we may not get the information necessarily about the.
But this was an attachment to the arrest affidavit.
Judge, I don't have that. It's not part of the bond hearing. The bond hearing is for the arrest forms. I'm asking that this court not find 65 years or older.
Did they have it on the arrest form?
That's not the arrest form, Judge. The arrest form is what you and I have in terms of that third page. They always have that. That doesn't get released to the parties or as part of the discovery.
It's
We would also like to state though that the arrest warrant, if they want to, cross-examine the officer about how he knows the age, but the officer swore when he wrote the affidavit that the victim was over 65 years old, and that would be sufficient to find probable cause.
I'll again argue, Judge, that the pages that Your Honor has right now, without that amendment, does not, excuse me, State, I did not interrupt you. Please allow me to lay my arguments. The arrest form, page 1 and 2 that was received this morning by defense counsel and that the judge has in front of her right now, does not have the date of birth as it's required. Can they file a different case at a later time? Of course. Right now for bond hearing is whether or not the four corners in the page 1 and 2 that I have established that, and that's why I inquired. Judge, does your copy have that? Because then my argument falls flat on the face.
Right.
That's not the case.
The A form I'm looking at states the victim is over the age of 65.
It does not have a date of birth. As such, there's nothing that includes that, and I'm going to renew my argument that per the statute 784.082C, it has to have all the information.
And it does have the information that meets the statute, which is saying that the victim is over 65 years old. The officer attests to that, and this is just for probable cause. This is not for us to necessarily prove beyond a reasonable doubt that the victim is over 65, but the A form itself should, within the four corners, it states that the victim's over 65.
All right, I'm gonna go ahead and find probable cause over the objection of the public defender, and we'll go ahead and standard bond is how much? Go ahead and set standard bond at 5. In addition, I'm gonna issue a stay away order. Please have no contact with Louis Legends. Angel Blandon.
Judge, what was the bond for Mr. Moore?
5,000 and a stay away order.
Thank you.
Angel Blandon.
He's present before the court.
Okay, Mr. Blandon is charged with possession of controlled substance, possession of cannabis, 20 grams or less, and possession of drug paraphernalia with intent to use.
The state's going to ask for an elevated bond of $2,500 for each count, plus the $500 for each.
He's charged with 12 counts of possession.
Correct.
Controlled substance.
May I be heard?
Let's finish his argument. Go ahead.
Oh, no, we're just clarifying. Yes, it's 12, but it's just standard bond. What we're asking for.
Posting a single bond.
Standard bond. Yeah, standard bond for each count, Your Honor. My apologies.
All right. Madam PD, would you like
Yes, Your Honor. The four corners of the arrest form indicate that there's alleged marijuana. However, in the state of Florida, hemp, Delta 8, they're legal. There's nothing that establishes an active THC strain. Furthermore, the controlled substances that are listed are antidepressants. There's no indication of resale or attempts to resell the items or anything like that, Judge.
Yeah, he was just charged with possession. I don't even know what that is. Accessible brand.
The clostridine, yeah, that's an antidepressant, Your Honor. But it is a controlled substance.
Does public defender have an argument? Anything else?
In terms of the alleged controlled substances, Judge, I understand that it's just the arrest and the officer was doing their duty. I'm sure that in just speaking with my client, we're gonna be providing other proof to the state that it's not an illegal possession of those antidepressants. And just given the fact that there's indication of some other matters, the way that it starts the reading of the arrest form, Judge, I don't think incarceration would be an appropriate alternative at this time. I'm looking that he doesn't have any priors. Would your honor be inclined to release him for pretrial services with an alternate of a monetary bond? And that way we can work with the state to provide whatever we need to in terms of the defense.
Want to say anything else? Because I'm inclined.
Yeah,
Release him through pretrial services. So find probable cause, release him through pretrial services with an alternate bond. I mean, there's 12 accounts. I mean,
Your Honor, we would ask for standard bond, but we're inclined to defer it to the court's judgment. Yes.
yeah, no, I'm gonna release him through pretrial services, but an alternate bond for each count. Is that what you're requesting?
You can do, the state can request that maybe a reduced bond of $1,000 for each count.
No objection.
Is cannabis related? Great. All right, I'll release him through pretrial services with alternate bond of 1,000 for each of the 12 counts of possession. And the misdemeanors.
No misdemeanor.
Okay, do we already? There, I mean.
The standard bond would be okay for the state for you.
Yeah.
And then for the two misdemeanors, standard.
Yeah. That's fine.
Sir, get some help. Daniel Rios.
Judge, what was the bond for counts 13 to 14?
500, 700 standard. Danielle Rios.
With the services of the interpreter.
He's been charged with one count of tampering with physical evidence and resisting arrest without violence.
Señora, usted se le imputa manipular evidencia física y poner resistencia al arresto sin violencia.
State's gonna ask for a standard bond.
La fiscalía solicita fianza estándar.
And may I be heard?
Yes.
As to the allegation of tampering, Judge, there's no evidence in the four corners of the arrest form that this is the individual. Sorry, I'm mixing up. Oh, give me 1 second.
Rios. Does he have prior convictions or arrests for drugs?
No, he just has, he has a manslaughter charge, Your Honor, conviction for a deadly weapon. 2008. And then he had a concealed weapon from 2007, Your Honor. But the manslaughter, he was sentenced to almost 10 and a half years.
Tiene antecedentes que datan del 2008-2007, es cierto, más de 10 años.
Yes, Judge. In terms of the argument, yes, I finally found it. May I be heard? Yes, Judge, there's indication that this officer came out of an unmarked police vehicle. My understanding is from crime suppression detail, sometimes they're fully uniformed. I would argue in the state of the times that we see news of people impersonating officers. So at this time, this individual would not have known that this was a lawful officer commanding him to do certain orders.
Your Honor, but
El agente policial que lo paró no estaba debidamente identificado, bajó de un vehículo que no estaba marcado y ya en los momentos que estamos viviendo hoy en día no hay manera de que usted supiese de que en efecto ese era un agente de la ley.
Your Honor, by the defense's argument that anytime someone sees an officer walking down the street, they don't have to necessarily obey or, follow any orders because, they may not be an officer. I mean, it's very clear he's in his uniform and saw them coming and destroyed the pipe, thus destroying evidence of any potential crime of drug use, So we're going to ask that this court find probable cause.
La fiscalía argumenta que cuando usted vio al agente uniformado bajar del vehículo que no estaba debidamente marcado, usted de inmediato procedió a romper o deshacerse de las pruebas.
I mean, he's alleging he's wearing his police issued uniform. So the court will go ahead and find probable cause. We'll do standard 2,500 count 1 and 150 count 2.
Count 1, 150, Your Honor, also?
Count 1, 2,500, count 2, 150.
Thank you, ma'am. Su señoría encuentra causa probable, fianza para el cargo 1, $2,500, fianza para el cargo 2, $150.
Kurt Allen Crandall.
Present before the court.
And Mr. Crandall is charged with 1 count of grand theft in a vehicle.
And Judge, the state has a motion for pretrial detention pursuant to Florida
They don't
statute.
qualify, no.
I have argument, Judge.
Are you asking for pretrial detention or no?
I do, Your Honor.
On Kurt Allen Crandall?
They want, but it's, then that, you try to, and then apply for that. Charge.
Judge, it is a first degree felony.
It's not capital. Okay.
That form does not.
Okay. All right. So no pretrial detention. All right. Let me just review the A form.
Check. Start going. Okay. Pages.
What would you like to say?
Yeah.
Yes, Your Honor. In the reading of 812.0,
Your Honor.
Go ahead.
0142A1, the statute requires that the value of the property be $100,000 or more, or is a semi-trailer that was deployed by a law enforcement officer. Just reading the statute and the arrest form, it doesn't meet the elements of that particular crime. So I'm asking that this court find that there's no probable cause for the F1 that is in terms of this particular case. There's also no evidence that this individual was involved in the alleged initial taking or that he knew that it was stolen in any way, Judge. There's no indication that the ignition was popped, that there was any items that he was using to run the vehicle or to let him know that it was stolen or anything like that, Judge. So I'm asking that this court find that there's no probable cause in the 4 corners of the arrest form and release him outright.
Judge, the arrest form clearly states that there was a Volvo SUV and the main frequency for a stolen white Toyota. This happens to be the same car in which the defendant enters through the front driver's side, and then sits in the driver's seat and attempts to turn on the vehicle. So I would argue that Here we meet the elements of grand theft of the vehicle. In addition, the state is moving for pretrial detention. I'm reading here our motion. It says that on a carjacking, we can go ahead and move for pretrial detention, and it is a first-degree felony.
This is not a carjacking. Are they changing the charge?
It's what, March 4th, it doesn't. No.
What? I'm sorry, Your Honor. May I get some clarification because I'm getting confused?
We're not, Your Honor.
They're
We're
not-
withdrawing.
Yeah, there's no request for pretrial detention.
Understood.
All right, and then do you want to, I don't think you addressed her argument, or you did, and you're done.
That's correct, Your Honor. We're just once again asked for standard bond. Huh? The $2,500 to count,
That's not the correct one. It's this one.
oh, my apologies. Give me a second.
That's for a $10,000 bond.
What I'm gonna do is I'm gonna go to those, did he have priors?
No, he doesn't have any priors, Judge. That's something I was gonna ask for pretrial services if the court was inclined.
I'm going to release through pre-call services for the alternate bond, 10,000.
Thank you. What was the amount, Your Honor? 10,000?
Alternate bond. Then.
That's a bond out.
Yeah. Adonis Quintana Ferreira.
Present before the court. We need the services of the interpreter, please.
Mr. Ferreira is being charged with 1 count of trafficking cocaine.
Se le imputa un cargo de tráfico de cocaína.
Oh, yes. We're gonna ask for.
State's gonna ask for standard bond, but we're also gonna ask for a nebia. A nebia requirement. Yeah, because the nature of the charge.
La fiscalía solicita una audiencia nebia.
15, 10 or 15. 15. Would the public defender like to be heard?
Yes, Your Honor. In terms of the reading of the arrest forms and the reading of the statute, there's no indication that he sold, purchased, manufactured, or delivered. It's just possession, Your Honor. That would be defense's position.
Your Honor, it still clearly states that black container containing multiple baggies of crack cocaine were under the driver's seat. that's not indicative of intent to distribute in traffic, I don't know what is.
La defensa argumenta de que no existe nada en el atestado de arresto y tampoco en la ley que indique que usted tenía la intención de producir, vender, comprar y repartir la droga. La fiscalía dice que sí.
All right, we're just gonna find probable cause and it's gonna be $15,000 with Nebia, with the Nebia hearing.
Su señoría encuentra causa probable para el delito que se le imputa. La fianza es de $15,000 más una audiencia Nebia.
Joseph Washington. Yeah. And Mr. Washington is being charged with.
He's here.
One count of possession of ecstasy. One count of possession of cocaine. And possession armed.
State's gonna ask for standard bond. Sorry, state's gonna ask for standard bond.
May I be heard, Your Honor?
Yes, go ahead.
In terms of the armed, the four corners of the arrest form don't indicate. I would argue that's a simple, that count one should be no PC, release outright. If you look at the top where it says weapons seized, none. Furthermore, in the description of the narrative, it doesn't indicate any knives, weapons, or ammunition. So as such, I'm asking this court not find probable cause as to count one. Release him outright and enter pretrial services with a, based on his no priors, enter pretrial services with an alternate reduced monetary bond on count 2 of $1,500.
One moment, Your Honor.
Probably the statute. I mean, the statute specifically requires being armed.
I'm not really.
Leaving B3, 1, 2, sub 6, sub A,
One moment, Your Honor. We are checking.
because he's being charged on the second count with the same statute and does not include anything regarding being armed. Well, that's a secondary felony, that's the first one.
Your Honor, it doesn't seem that that is a requirement. All that states is that they may not be in actual construction possession of a controlled substance. Such controlled substance was lawfully obtained pursuant to a valid prescription, and there's
Yes, the statute reads, a person may not be in actual or constructive possession of a controlled substance unless such controlled substance was lawfully obtained from a practitioner or pursuant to a valid prescription or order of a practitioner while acting in the course of his or her professional practice, or to be in actual or constructive possession of a controlled substance except as otherwise authorized by this chapter. The person that violates this provision commits a felony of the 3rd degree. That's 6A.
Still doesn't negate the fact, Judge, that there's no indication on the arrest form or anywhere that he should be held as to count 1 because he's not armed. There's nothing that indicates that.
I understand, but the statute doesn't seem to require any requirement of being armed.
It's not, it's contained on the A form, and that's why it's 2nd degree. Is what I'm assuming. So it was bumped up to a 2nd from a 3rd. what I can do is I can find probable cause as possession of ecstasy. The possession on count one of ecstasy. And possession or probable cause, I found probable cause as to count two. And I'll set the bond at 2,500, 2,500. Did you say he was eligible?
Judge, I'm asking that you release him outright on the first count or reduce the monetary amount.
Hearing is, I believe he's going to be eligible for pretrial.
Oh, okay. That was gonna be my other
Yeah.
request.
So,
alternate.
pretrial services with alternate bonds of 25 and 25.
Understood.
Ricardo Ferrer. Is that Mr. Ferrer?
That's correct, Judge, with the services of the interpreter, please.
Got two cases. Mr. Ferrer is charged with driving a license suspended after a third and subsequent conviction. Driver's license expired, and that is to police case or to court case number F2512321. And on F2512320, he's being charged with possession or vehicle with an altered ID.
Judge, we need the
Señor Ferrera, usted se le imputa manejar con una licencia de conducir suspendida, siendo esta su tercera condena, y manejar con una licencia de conducir caducada. Esto con respecto a la causa número F25-12321. Ahora, con respecto a la causa F25-12320, usted se le imputa tenencia de una identificación modificada o alterada.
State's gonna ask for elevated bond per count. He has multiple priors, including multiple felony priors, including that involve grand theft and vehicles.
La Fiscalía solicita una fianza elevada debido a que usted tiene múltiples antecedentes, incluyendo delitos mayores.
Detail the LLS convictions.
And while these are somewhat more, some of these convictions are a little more in the past, I guess, it's still the number of them is concerning.
Judge, may I be heard?
Yes, as to which case?
Mr. Ferrer, all of the priors are dating back to the 80s. The most recent one is a 05 case for a controlled substance possession. In terms of the other cases that now he's facing, there's no indication that he was the one that altered the ID of the vehicle he was found allegedly driving. There's just indication that the police observed it. There's nothing that indicates that he was the one that did that in terms of that charge.
Los casos que usted tiene datan del año 80 con respecto a la modificación o manipulación de la identificación. No hay nada que indique que usted es responsable de eso.
Your Honor, the statute just states that it's a vehicle with the altered ID in possession of one. It doesn't require that the defendant themselves did it. And it's very clear that the PC for the stop was lawful, and section of the made it very clear that it was turned it down. And so we'd ask that the court find probable cause.
Your Honor, again, there's no indication on the arrest form that indicates that he had knowledge or that he did it. I'm asking that this court take that into consideration since I'm requesting pretrial services as a release for the cases in front of this court.
Not eligible for pretrial.
A pesar de que su abogada solicita que lo pongan a usted bajo la supervisión del programa Pretrial Services, su señoría dice que usted no califica.
Judge, the charges are qualifying charges. Is there another reason that's being expressed why he wouldn't qualify for PTS?
He's a Signal 200 career offender.
Can you translate that, please, so that he knows?
I couldn't get, Your Honor, he is
a Signal 200 career offender. He's not eligible for pretrial services.
Él no califica. Su abogada pidió una explicación por qué usted no califica para el programa. Usted no califica porque se le considera un infractor habitual, en este punto y un delincuente habitual de tránsito.
All right, what I'm going to do is I'm going to find probable cause for count 1, driving license suspended, issue the standard bond, 2,500. Count 2, possession with an altered ID, the vehicle, 2,500. And as to the vehicle with an altered ID possession. I mean, there was 2 counts. Sometimes held to 1 count. It's set a standard 100.
The judge, your low corrections can't hear you.
Yeah.
I didn't do it backwards, and I'm looking at this. This is driving license. Okay. In case F25-12321, there's 2 counts. The first count is driving with license suspended.
No, judge, on that case, it's only 1 count.
The second count might have already been addressed.
He also had a traffic from this morning. He received the $150 bond on that case.
That was the driver's driving license expired?
That's correct. So now we need to address the driving while license suspended.
I'll find probable cause in 2,500.
Okay.
Right. And then also possession with an altered ID, possession of a vehicle. There was 2 counts. And I'll go ahead and find probable cause as to 1. I don't know why there's 2 counts.
Okay, no probable cause release.
No PC for count 2. I mean, 2,500 on the first one, and I think that's fine.
Ok. Muy bien. Con respecto a la licencia de conducir suspendida, eso ya nos hicimos cargo y la fianza fue $150. Ahora, con los 2 delitos frente a su señoría encuentra causa probable para el delito número 1, fianza $2,500. Para el cargo número 2, su señoría no encuentra causa probable.
Christopher Houghton. Okay, Mr. Houghton is being charged with 1 count of possession of the cannabis, 1 count of carrying a concealed firearm, and 1 count of grand theft in 3rd degree with a firearm.
He's present before the court, Judge, and I have argument.
State's gonna ask for standard bond, Your Honor.
All right, let me review the A form.
I'm not sure.
Okay, what would you like to say? Madam Public Defender?
Your Honor, in terms of the arrest form and how it reads, there's no indication that there is an active THC strain in the state of Florida. Hemp and Delta 8 is legal. So, and there's also CBD. I would argue that there's nothing establishing that that's THC. In terms of the alleged concealing, there's no probable cause or indication on the arrest form that this individual that was arrested had knowledge that before the officers approached, there was a firearm or any object related to a firearm or accessory. The arrest form does not indicate that the officers saw this individual as they were approaching throw anything into a bag or do any furtive motions. And then as to the grand theft, there's only indication of possession. There's nothing that indicates that this isn't the individual that permanently deprived or had the elements of the crime, judge. So I'm asking that this court not find probable cause based on those arguments. And given the fact that he doesn't have any violent priors, release him to pretrial services, alternate reduced monetary bond.
Your Honor, I mean, well, we certainly respect them. I'm public defender. I think some of these probable cause arguments are kind of say frivolous. I mean, look, they lower the car door, they smell marijuana, whether CBD is legal or not, they smell what they believe to be marijuana. You know, from both his opinion as an officer and the lay opinion, I think they can, that is enough for certainly probable cause. Additionally, they don't have to prove for this probable cause, it doesn't have to prove beyond a reasonable doubt that the defendant was in possession, like, you know, it was in fact his, or, you know, the backpack with his. This is simply finding a probable cause. It is a very low bar, and I think that the four corners of the A form clearly show that there is probable cause to find that the defendant concealed a firearm. What did have, well, just that there's probable cause for counts 1, 2, and 3.
All right, the court's gonna go ahead and find probable cause. Count 1, I'm gonna go ahead and set the bond at, I'm gonna reduce that to 3,000. Count 2 would be 2,500. And count 3 would be 2,500.
Denying my request for pretrial services.
That's gotta be done.
May I get the name of the state attorney that's saying that I'm making frivolous arguments? I'm sorry?
ASA Hunter Lyles.
Ariel, I say Carraza Racinos. We already have it.
With the services of the interpreter, please.
One count on our cover sheet might have.
Got it.
Okay, so, yeah, I don't know why these things are addressed at the same time. We feel the same. Yeah, I don't understand that. Two separate tapes. Yeah, but it's really, it should be handled all together. So this is just the possession. Right. Okay, so on this calendar, he's just being charged with 1 count of possession, cocaine for the intent to sell, manufacture, deliver.
That's correct, Judge.
Right.
En ese calendario usted se le imputa tenencia de cocaína con la intención de vender, producir o entregar.
I have argument whenever the court is ready, Judge.
Go ahead.
In reading the arrest form in the 4 corners of the arrest form, there's no indication that it was with intent or soliciting. It is a mere simple possession.
Su señoría, la defensa argumenta que en la totalidad del atestado de arresto no se indica en ninguna parte que haya sido la intención de vender, es simplemente tenencia.
As such, I'm asking this court release him outright, as the arrest form doesn't include the information.
Por eso se solicita la liberación inmediata, ya que el atestado de arresto no incluye la información.
was discovered Mr. Racino's wallet had a small clear baggie with a white powdered substance, suspect cocaine.
Yeah, the state's going to stipulate to it just being for the first count being just for possession.
Yeah.
Se estipula que el cargo 1 debería ser solo tenencia.
Possession, it's just 2,500.
Standard of the whole thing was 2,500 or the borrowing, I'm not sure. It's up to your discretion.
All right, so I'll just find probable cause for possession.
Su señoría encuentra causa probable para el cargo de tenencia.
I'll just set, I want to set the bond to 1,500.
Y se establece la fianza en $1,500.
$1,500, yeah. Jose Miguel Pinto. Didn't we also have Mr. Pinto?
He's present before the court. He was on this morning, also on county judge.
Go ahead.
So you're just addressing the first two substance possession and name after arrest, false name after arrest.
All right, so he's being charged with 1 count of possession of a controlled substance, Xanax, giving a false name after arrest.
I have argument whenever the court is ready.
Okay, let me review the arrest affidavit. Okay, what is your argument?
Yes, Your Honor. In terms of the controlled substance that was found, there's nothing that indicates that this individual had knowledge or actually physically possessed it. It was in a vehicle. There is no indication that he went into the vehicle knowing that the items were there. There was no statements asked to that once the police did speak, because there were spontaneous statements, Judge. As such, I'm arguing that he didn't have any knowledge, didn't possess it. For the allegations in terms of the arrest form and how it reads, I'm asking this court release him outright as to count 1. I'll remain silent as to count 2.
Your Honor, we're going to ask that the court find probable cause as to count 1. I mean, he is arrested in possession of the vehicle, and when he's arrested, it seems that he's the only person in the vehicle. He was in possession when he was driving it, and then after that, the impound, it was seized. That's when the controlled substances were found. The state asked the court to find probable cause based off of that. It seems that he was in constructive possession when he was driving, Your Honor. When he was driving the vehicle with the controlled substances in it.
All right. The court's going to find probable cause as to both counts. We'll do the standard 2,500 count 1 and 500 count 2. Christian Joel Sanchez Roman.
With the services of the interpreter.
Mr. Sanchez Roman is being charged with, one count of possession of cocaine, one count of fleeing and eluding, one count of driving when license suspended, and revoked, and one count of tampering with physical evidence.
Muy bien, señora, a usted se le imputa un cargo de tenencia de cocaína, un cargo de eludir y huir, un cargo de manejar con una licencia de conducir suspendida o revocada y manipular evidencia.
Sorry, state's gonna ask for standard bond.
La Fiscalía solicita fianza estándar.
May I be heard, Your Honor?
Yes.
In terms of the four corners of the arrest form, there's no indication that anything was tested. Glass pipes could be used for different substances, not just controlled substances. In terms of the history, he doesn't have any violent priors. So in terms of what I'm arguing specifically, I'm arguing the tampering and the cocaine possession. I'll remain silent as to the other counts, Judge, and I'm asking if this court release him for pretrial services, given the fact that he doesn't have violent priors.
Lo que solicita su abogada con respecto al cargo de manipulación de evidencias y tenencia de cocaína es que, según el atestado de arresto, nada de lo que usted tenía fue probado para verificar que era una sustancia ilícita o controlada y que usted no tiene antecedentes violentos y por eso pide que lo liberen bajo la supervisión del programa Pretrial Services.
Your Honor, the state's arguing that as count 1 and 4, I believe that's what the Madam Public Defender is arguing. He doesn't have to, we don't, for probable cause to be met, the state doesn't have to prove beyond a reasonable doubt that it was cocaine. It's just clear that, you know, the officer observed a white plastic bag being thrown out as he approached. I think there's probable cause for him to come to the conclusion that it was, at least at the very least, controlled substance, and that act in itself is tampering with physical evidence. So we would ask that the court find probable cause.
La Fiscalía solicita que se encuentre causa probable, ya que no se necesita probar que era cocaína, pero el oficial observó que usted tiró una bolsita de plástico. Eso ya también es, ese simple hecho es manipular evidencia, así que solicitan que encuentre causa probable.
Did we already, I'm sorry, did we already address the count 5s and count 6?
No.
No, Judge.
He's also charged with possession of drug paraphernalia and of resisting an officer without. So I apologize, that was on the second page of the works.
Hay dos cargos más que no se leyeron, que es el cargo 5 y el cargo 6. Se le imputa un delito de tenencia de adminículos para el consumo de droga y poner resistencia al arresto sin violencia.
What I'm going to go ahead and do is support these can find probable cause as to all counts. Count 1, set on at 2,500. Count 2, 2,500. Count 3, 2,500. Count 4, 2,500. Count 5, 500. Count 6, 500.
Su señoría encuentra causa probable para los delitos que se le imputan y la fianza para el cargo 1 es de $2,500, para el cargo 2, $2,500, para el cargo 3, $2,500, para el cargo 4, $2,500, el cargo 5, $500 y el cargo 6, $500.
Are you denying my request for pretrial services, Judge?
He, being told he does not qualify.
No calificas. Entonces
Usted no califica para los servicios de Retail Services.
Rainier Rodriguez. All right, Ms. Rodriguez is charged with one count of possession of possible methamphetamines and possession of drug paraphernalia with intent to use.
With the services of the interpreter, please.
Oh. Your Honor, the first charge is possession of methamphetamines, and the second one?
It says possession cocaine, possible meth, and count 2 is possession with intent to use of drug paraphernalia.
Muy bien. A usted se le imputa el delito de tenencia de cocaína, posiblemente metanfetamina, y tenencia de adminículos para el consumo de drogas.
State's gonna ask for elevated bond. He has multiple priors of charges of the same nature.
La Fiscalía solicita fianza elevada por sus antecedentes.
Some of the earliest this year.
Que algunos son incluso de principios de este año.
Judge, may I be heard?
Yes.
There was no probable cause or reasonable suspicion to interact and stop with this individual at the first time. Just reading on the arrest form, patrolling an area and knowing things is not just a reason alone. I would argue that it's a pretextual stop, even more that they know that he has priors or instances, as the state relied in their argument in terms of the priors that they're mentioning. None of them are violent priors. I'm asking this court release him to pretrial services. In the alternate, I apologize. I'm asking for TAP because he is homeless. So that's what I'm asking for this particular case, Judge.
Lo que pide básicamente la defensa es que usted lo ponga en el programa TAP, ya que usted es una persona en situación de calle.
Okay, what would you like to say?
Yes.
I mean, obviously he's got a drug problem,
Of
so he needs help.
of course.
So can he get help in TAP? We'll help get him in. They won't necessarily. They don't help with the drugs? Once he's in action.
I mean, we're still gonna stipulate to or ask the court to have standard bond at the very least. However, we will defer to the court's discretion.
La Fiscalía solicita igual que le pongan fianza y que se deja a discreción de su señoría.
That would be example. With the alternate. Okay, well, what I'm gonna do is I am gonna find probable cause, but I will release him to the TAP program with an alternate bond, account 1, 2,500, and count 2, 500.
Su señoría encuentra causa probable para los delitos que se le imputan. Lo va a liberar bajo la supervisión del programa TAP y o de lo contrario, usted paga una fianza de $2,500 para el cargo 1 y de $500 para el cargo 2.
Good luck, sir.
Buena suerte, señor.
Carlton Johnson.